Good morning, ladies and gentlemen. Good morning, ladies and gentlemen. On behalf of Vinayaka Missions Law School and the Center for Maritime Law, I extend a very warm welcome to all dignitaries, guests, members of the bench and bar, faculty, students, and friends from the maritime community. We are honored by the presence of Honorable Justice Syam Kumar VM, Judge, High Court of Kerala, Sri Amitava Raja Majumdar, Managing Partner, Bose and Mitra and Co., Dr. A. Francis Julian, Senior Advocate, Supreme Court of India, Honorary Chairperson, VMLS Center for Maritime Law, Advocate Hari Narayanan, Partner and Maritime Lawyer, United Maritime Law Chambers, Sri Amitava Raja Majumdar, Managing Partner, Bose and Mitra and Co., Dr. Mohit Gupta, Assistant Professor, Delhi University, Captain Pankaj Kapoor, Managing Partner, Quadrant Legal, Sri Debashish Mukherjee, Manager Legal, Synergy Maritime Private Limited, Anthony R. Julian, Advocate, Supreme Court of India and Convener, Steering Committee of CJT at VMLS, and Dr. Anant Padmanabhan, our own Dean of Vinayaka Missions Law School. We are deeply grateful for your presence today. To commence today's proceedings on an auspicious note, let us all rise for the Tamil Thai Valth.
நீராறும் கடலுடுத்த நிலமடந்தை கெழிலொழுகும் சீராறும் மதனமென திகழ்வரத கண்டமிதில் எக்கணமும் அதில் சிறந்த திராவிடனல் திருநாடும் தக்க சிறு திரை முதலும் தரித்தனரும் திலகமுமே அத்திலக வாசனை போல் அனைத்துலகும் இன்பமுற எத்திசையும் புகழ் மணக்க இருந்த பெரும் தமிழனங்கே தமிழனங்கே உன் சீரிழமை திறந்தியந்து செயல் மறந்து வாழ்த்துதுமே வாழ்த்துதுமே வாழ்த்துதுமே.
Thank you everyone. Please be seated. We now commence the ceremonial lighting of the lamp, a solemn tradition symbolizing the trump of knowledge and virtue. May I invite our dignitaries, Honorable Justice Syam Kumar VM, Sri Amitava Raja Majumdar, Dr. A. Francis Julian, and Dr. Anant Padmanabhan to kindly come forward for the ceremonial lighting.
Thank you, everyone. To formally inaugurate this event and set the tone for the day, I'm honored to invite Dr. Anant Padmanabhan, Dean of VMLS, to deliver the welcome address. Dr. Anant is an expert in intellectual property rights and technology policy. He has been serving as Dean of VMLS since July 2023 after completing the MSX Sloan Fellow 23 program at Stanford Graduate School of Business. He has authored the treatise Intellectual Property Rights, Infringement and Remedies and co-edited India as a Pioneer of Innovation. His research on big data and regulation builds on contributions in rethinking public institutions in India and the Oxford Handbook of the Indian Constitution. He engages widely in public conversation through opinion pieces in Hindustan Times, The Print, Live Mint, Indian Express, and other media. Dr. Anant holds master's and doctoral degrees in law from the University of Pennsylvania Carey Law School and a BA LLB honors from NLSIU Bangalore. He previously served as founding dean of SAR University Law School, led the technology and policy research vertical at Carnegie India, curated the first Global Technology Summit, and created the Daksha Fellowship. Dr. Anant, we invite you to kindly address the gathering.
Thank you, Sarvamita. Distinguished guests, Honorable Justice Shyam Kumar, Dr. Francis Julian, Shri Amita Majumdar, Captain Pankaj Kapoor, Advocate Hari Narayan, Shri Debashish Mukherjee, Dr. Mohit Gupta, Mr. Anthony Julian, esteemed faculty and dear students, it's really a profound privilege to welcome you all to this Maritime Law Summit 2025, charting the course for cargo, contracts and claims. This is also a long-held dream for us because for a long time we have been looking to inaugurate formally our Center for Maritime Law at Vinayaka Missions Law School, though some work has already happened under the center, under the guidance and stewardship of our beloved faculty, Professor Saravanan. Usually, as you know, I do not prepare except, have a few bullet points. But today I have a prepared speech and there is a very specific reason for that. This is maritime law. I have no idea what it is about. I never really got to do anything in maritime law as a student of law, as a practitioner, and subsequently as a academic. It's such an advanced, sophisticated and highly technical area of practice and study. And therefore, I thought instead of embarrassing myself speaking about something which I'm really not an expert in, I'd rather have this prepared speech here. I do know that there are massive trends happening in this field, and I hope that today's conference captures some of that within the limited one day that we have to discuss them. The summit theme of today, cargo, contracts and claims, it represents really the trinity of modern maritime commerce. As we gather to inaugurate our center today, we witness an unprecedented period of transformation in global shipping and maritime jurisprudence that makes these discussions not merely academic, but urgently practical. The maritime industry today operates in a very complex ecosystem, where traditional principles of admiralty law are rapidly intersecting with evolving commercial practices, environmental mandates, and technological innovations. For instance, a paper that I came across recently was about unmanned ships and the law of salvage, how that would apply in the case of unmanned ships. Recent legislative reforms, including India's modernization of maritime laws through the Merchant Shipping Act 2025, the Carriage of Goods by Sea Bill 2025, these have all aligned our legal framework with international standards while addressing contemporary challenges in cargo handling, contractual obligations, and dispute resolution. Cargo operations indeed form the foundation of our maritime economy, with over 90% of global trade moving through sea routes. Yet, this fundamental aspect of shipping presents increasingly complex legal challenges. Modern cargo claims involve intricate questions of misdelivery, damage assessment, and non-payment disputes that require sophisticated legal frameworks. Maritime contracts, particularly charter party agreements, represent the architectural framework within which global shipping operates. The rights and obligations of ship owners and charterers have evolved significantly, influenced by changing trade patterns, fuel price volatilities, and environmental compliance requirements. Modern charter party disputes increasingly involve questions of performance under environmental constraints, where traditional commercial expectations must align with new regulatory realities. The obligation of ship managers in contemporary shipping extends beyond traditional vessel management to encompass environmental compliance, crew welfare standards, another very important area, and technological integration, each creating new dimensions of contractual liability. Maritime claims and their resolution represent the critical mechanism through which commercial certainty is maintained in our industry. The Admiralty Act 2017 has provided enhanced procedural frameworks for ship arrest and cargo claims, yet judicial interpretation and practical implementation continue to evolve, matters on which today we will hear from our distinguished guests. Contemporary claims practice must address not only traditional areas of freight disputes and demurrage calculations, but also emerging challenges related to environmental compliance failures, cyber security incidents, and autonomous vessel operations. The increasing complexity of ship management structures requires a sophisticated understanding of liability allocation across multiple service providers and jurisdictional boundaries. Our Center for Maritime Law emerges at this critical juncture to address the growing demand for legal professionals who understand these intersections of cargo operations, contractual frameworks, and claims resolution. The Center's mission extends beyond traditional admiralty law education to encompass the practical skills required in modern maritime practice. When I see this, I wonder, when I go back to my time at NLS, if we had a center like this, perhaps, I would have taken up the study of maritime law much more seriously, at least have had a working knowledge of this fairly sophisticated area. So the distinguished panel we have today brings together practitioners who navigate these challenges daily. Their insights into vessel arrest procedures, cargo claims under the Admiralty Act, charter party negotiations, and bills of lading complexities represent the practical wisdom our students and profession require today. The discussion will address procedural hurdles in maritime litigation, judicial interpretations of modern shipping contracts, and common disputes involving fray and demurrage. Topics that directly impact the daily practice of maritime law and the commercial viability of shipping operations. The theme of today's summit, Charting the Course for Cargo, Contracts and Claims, reflects our commitment to navigating the evolving landscape of maritime law with both practical wisdom and forward-thinking vision. As global commerce continues to rely on maritime transport, the legal frameworks governing cargo operations, contractual relationships, and claims resolution must evolve to meet contemporary challenges while preserving the certainty essential for international trade. Today's inaugural ceremony marks not just the establishment of an academic center, but hopefully the creation of a hub for advancing practical solutions to the complex legal challenges facing modern maritime commerce. Thank you all for joining us on this significant occasion, and I look forward to the invaluable insights that will certainly emerge from today's discussion on these critical aspects of maritime law practice. Thank you very much.
Thank you, Dr. Anand, for your insightful welcome and for outlining the vision for VMLS and the Center for Maritime Law. We shall now felicitate our honored guests of the inaugural ceremony and the panel discussion. I request Dr. Anand Padmanabhan, Dean, VMLS, to kindly felicitate Honorable Justice Shyam Kumar PM. Thank you, sir. I now request Dr. A. Francis Julian, Honorary Chairman, Center for Maritime Law, VMLS, to kindly felicitate Sri Amitava Raja Majumdar. sir. I request Professor Saravanan Ravi, Assistant Professor and Faculty Coordinator, Center for Maritime Law, to kindly felicitate Dr. A. Francis Julian. Thank you, sir. I now request Dr. Krishna Kishore, Assistant Professor VMLS, to kindly felicitate Captain Pankaj Kapoor. Thank you, sir. I now request Professor Mike Rubin, Assistant Professor VMLS, to kindly felicitate Sri Debashish Mukherjee. Thank you, sir. I now request Professor Narayanan, Assistant Dean VMLS, to kindly felicitate Advocate Hari Narayan. Thank you, sir. I now request Dr. Faumina, Associate Dean and Director for Center for Access to Justice, VMLS, to kindly felicitate Dr. Mohit Gupta. Thank you, ma'am. I now request Dr. Sangamitra, Associate Dean, to kindly felicitate Mr. Anthony R. Julian, Advocate, Supreme Court of India, and Convener, Steering Committee of Center for Justice at VMLS. Thank you, ma'am. We now proceed the inauguration of the Center for Maritime Law at VMLS, an institutional commitment to excellence in maritime legal education, research and collaboration. May I invite our dignitaries to unveil the plaque and declare the center open. So kindly all our dignitaries to come on stage.
The center is now formally inaugurated. Our next address for this morning is by Dr. A. Francis Julian, Senior Advocate, Supreme Court of India, a honorary chairperson of our center. Dr. Julian has 50 years of standing at bar, has argued numerous cases leading to the reported Supreme Court judgments, and hold an SJD from Tulane University, an MCL from Southern Methodist University, and LLM and LLB degrees from University of Madras. He is employed as a maritime arbiter with this London Maritime Arbiter Association and an Indian Council of Arbitration, and teaches for international commercial arbitration and maritime law at OP Jindal Global Law University. His guidance is sought by the private universities, and he serves as a governing bodies in advisory capacity. Dr. Julian is a prolific writer and a speaker, contributing the national and international conferences, law journals, and legal reform discussions. His expertise span across the constitutional law, arbitration, and maritime disputes, making him highly respected figure both in academia and practice. Dr. Julian, we invite you to kindly deliver the keynote address.
Thank you. Honorable Justice Shyam Kumar, Mr. Amida Majumdar, Sri Captain Pankaj Kumar, Sri Hari Narayanan, Sri Debashish Mukherjee, Mohit Gupta, Anthony Julian, and distinguished faculty and students who are here. I am very happy to be here, part of the inauguration of the center, which is one of my dreams also, to have a strong maritime law center in Tamil Nadu, in Chennai. And in this address, I'll briefly touch upon the history, because there are other panelists who discuss on the maritime law in different scope, But my emphasis, we have very little research and study on the historical aspect, which is very much necessary, India being one of the ancient center on maritime trade and law. But the development is very, very little. So maritime law has been one of the oldest branches of laws in the world. Maritime law is defined as a corpus of rules, concepts, and legal practices governing certain centrally important concerns of the business of carrying goods and passengers by water. It regulates maritime matters on the surface area of sea, confining to merchant shipping and other surface operations. Ancient Indian maritime law was based on a combination of codified rules, customary practices that facilitated extensive trade and defended coastal regions for thousands of years. In the absence of fully codified laws, maritime affairs often governed by the custom of the trading communities involved in sea commerce. Vedic, Buddhic literature show flourishing seafaring activities much before the Christian era. South Indian history indicates that the Sangam period was a golden age for maritime trade. Sangam literature shows that Chera, Chola, Pandyan regions had renowned ports and engaged in extensive sea trade. Tamil traders dealt with Arabs, Avans, and Savakas, according to the literature. Exports during this era included jaggery, sugar, alcohol, pepper, salt, conch, textiles, pearls, timber, sapphire, and ivory. Mahabalipuram, which is a very coastal tourist place near our place, which was earlier known as Mamallapuram, was one of the ancient, well-known trade center and a port. So many of these things have disappeared now, but we have very little study on what was the law prevailing at that time. But unfortunately, modern maritime law is based on English common law, which is based on Lex Maritima. Lex Maritima has its origin on the maritime code of the Mediterranean, which was the Rhodian Sea Law of 900 to 200 BC. This was followed by Rolls of Aleron of France of 12th century, Law of Visby of Sweden of the 13th century, and Consolato del Mare of Spain of the 14th century. Admiralty courts were created in England in 1360 when the King of England granted the Admiral of Fleets the power to decide maritime disputes. Thus, maritime law emerged as a distinct set of laws separate from common law of England administered by common law courts of England. So this maritime law, the basis was not common law, but it was civil law. So this has led to constant clash between admiralty courts and common law courts on jurisdictional issues, leading to enactment of Admiralty Court Act of 1940, which vested both admiralty and common law jurisdiction on common law courts. Eventually, both jurisdictions were merged and vested on the High Court of Justice. Why this is relevant is, until recently, we are all governed by this history and historic developments, which was very sad state of affairs. So, pre-independence legal position in India. In 1865, the Letters Patent Act created Admiralty jurisdiction and vested the said jurisdiction on the Chartered High Court of Bombay, Calcutta, and Madras. Subsequently, under the Colonial Courts of Admiralty India Act 1891, the above three Chartered High Courts were vested with the same jurisdiction as was vested in the High Court of England. Thereafter, the Government of India Act 1915 and the Government of India Act 1935 preserved this power on the above three high courts. After independence in 1947, the Constitution of India of 1950 specifically provided for the continuation of the pre-independent jurisdiction with the three chartered high courts. Article 225 of the Constitution dealing with the jurisdiction of courts stated that the jurisdiction of and the law administered in the existing high court should remain the same as before. Article 372 provided that all laws in force in the territory of India before the Constitution should continue. Thus, even after independence, the Admiralty jurisdiction of the Indian courts continued to be governed by the over 150-year-old colonial laws and their interpretation by courts in India. This was administered by the high courts in England and Admiralty Courts Act 1861, though in England, subsequent legislation had enhanced the scope of the Admiralty jurisdiction of the High Court of England. This deplorable position was highlighted by the Supreme Court of India in 1992 in the case of M.V. Elizabeth. In this case, the Supreme Court was confronted with the question as to whether even after independence, the Admiralty jurisdiction in India remained as it was in England under the Admiralty Courts Act of 1861. The Supreme Court interpreted these pre-independence laws in terms of the Constitution of India, described the Admiralty jurisdiction as an essential aspect of the judicial sovereignty and the Constitution. The law is exercised by High Court as a superior court of record, administering justice in relation to persons and things within its jurisdiction. Supreme Court also held that the power to enforce claims against foreign ships is an essential attribute of Admiralty jurisdiction, and it is assumed over the ships while they are within the jurisdiction of the High Court by arresting and detaining them. So the Supreme Court held that any expression of Admiralty jurisdiction, any expansion of Admiralty jurisdiction of the High Court in England after 1861 has expanded the jurisdiction of the colonial courts of Admiralty in India. Supreme Court also emphasized the need for prompt legislative action to codify and clarify the Admiralty laws of India. Legal reforms. So, following the above decision of the Supreme Court, the Government of India made various efforts to enact law and the Admiralty jurisdiction of Indian courts. Also, the Law Commission of India recommended the enactment of an Admiralty Jurisdiction Act, as there were widespread demands from both domestic and foreign shipping industry for a new law on the subject. The Government of India introduced the Admiralty Bill 2005, which however was not passed in Indian Parliament. Eventually, the current act was introduced in the form of Admiralty Jurisdiction and Settlement of Maritime Claims Bill in 2016, which was passed in both houses of Parliament and became a law as on August 2017, aiming to consolidate the laws relating to Admiralty jurisdiction, legal proceedings in connection with vessels, their arrest, detention, sale and other connected matters. The Admiralty jurisdiction was conferred on the coastal high courts, Bombay, Madras, Kerala, Karnataka, Gujarat, Orissa and Hyderabad for the states of Telangana and Andhra Pradesh. I am not going into the intricacies of this act because they are sometimes, people don't understand how can you arrest a ship. There are jurisdictions, two jurisdictions, in personam jurisdiction and in rem jurisdiction. These are highly technical matters. Even the court also finds it very difficult to understand when we argue cases. So, and I leave it to the panel to discuss these matters. And of course, Raja, he knows much about than, he's dealing with all high courts in India now. And so, but it's a very interesting topic, but highly specialized one. So, I'm now coming to current legislative initiatives. Recently, there has been a series of new legislative initiatives which require proper research and study, throwing important challenges on the maritime industry by academics, practitioners and others. Some of the legislative initiatives are as follows. One is Bill of Lading Act 2025, replacing the colonial era of Bill of Lading Act 1856. Carriage of Goods by Act 2025, replacing Carriage of Goods by Sea Act 1925. This gives effect to the Hague-Visby rules, which is more modern. Indian Ports Bill 2005, a sweeping reform designed to replace the Indian Ports Act 1908, ending more than a century of colonial era regulation and ushering in modern framework on India's maritime sector. Coastal Shipping Act to regulate coastal shipping. I think first time India has introduced coastal shipping. which is very much necessary for, because now government has recognized, law has been passed, which is very, very progressive. The Merchant Shipping Act, which basically deals with the registration of ships and other many very important matters, replacing 1958 Act with modern, streamlined regulatory framework to align India's maritime law with international conventions. Despite these efforts, there is a need for new reforms in the light of new developments in containerization, development of technology, use of cryptocurrencies, automated unmanned already operating, and all existing maritime law will not apply, because who will be made responsible when nobody, no captain in the ship? No, these are all intriguing issues. There is a need for study and research through academic centers like Maritime Law Center, for which this center has been established in a Vinayaka Mission Law School. So then I will slightly talk what this center, is meant. The VMLS Maritime Law Center is intended to promote study, debates, discussions, and research on maritime law in India. Center will focus on research on contemporary issues in maritime law that are relevant with development in technology, such as payment in cryptocurrency and bitcoins, e-bills, and electronic documentary credits, automated unmanned ships. In undertaking such research, the center will try to propose and find answers to legal issues that are recognized globally. The center is strategically situated in Chennai, which has 3 major ports and also another in Tuticorin, has an old important shipping and trading center in India. Madras High Court, being a chartered and coastal high court, exercises admiralty jurisdiction, and admiralty lawyers have been practicing this branch of law for more than 150 years before this high court. Therefore, VMLS Maritime Law Center will have to play a very key role to promote research and teaching in maritime law. The primary aims and objectives are, these are some of them, but there are many more. One is to undertake teaching, research, and publish on important topics in maritime law and related subjects, promoting research at an institutional level on related area, influencing policy making on maritime matters and issues at state, national, and international levels, developing a global level scholarship and scholars ready to recommend industry and government, developing academic collaboration with national universities in the field of maritime law. There are 2 universities nearby. One is Indian Maritime University, another is Ahmed University, and other maritime universities. Now they are all recent origin. And international universities like Tulane, Southampton, and Essex. Establishing a resource center for students, academics, and maritime lawyers to access on campus studies and research. The one thing final is on maritime arbitration. I have been a maritime practicing in the area last 40 years. I think it's an important area, and much scope to, widen and, strengthen. So, there are not many maritime arbitration centers in India, even though we have so many disputes, maritime disputes. So, we also intend to start a maritime arbitration center in VMLS, so that, we can also contribute to the development of maritime arbitration. Thank you very much. Bye.
Thank you, Dr. Julian, for your profound insights. Our next address for the day is by Sri Amitava Raja Majumdar, Managing Partner, Bose and Mitra and Co. Mr. Majumdar founded Bose and Mitra and Co. in 2004 and has grown it into India's most recognized and acclaimed shipping and admiralty law firms. His expertise spans across all facets of shipping and trade, contentious, non-contentious, regulatory and policy work. He regularly argues before the Supreme Court, various high courts and arbitral tribunals, provides expert evidence on Indian law in the English High Court and the Singaporean courts, and is the go-to counsel for ship sale and purchase transactions. He represents Indian ship owners and associations in transactions across major maritime hubs worldwide and advises ship owners, charterers, commodity traders, P&I clubs and government departments. Mr. Majumdar is a leading practitioner for casualties, collision and salvage and has represented owners, charterers, salvage companies and the government in many incidents. He helped draft the Admiralty Jurisdiction and Settlement of Maritime Claims Act 2017, contributed to the draft Merchant Shipping Bill, and served on India's delegation to the IMO Legal Committee. Through his expertise, he is consistently ranked as a Band 1 practitioner in shipping by Chambers and Partners and Legal 500. Beyond his practice, Mr. Majumdar is frequently invited to speak at leading maritime conferences, delivers guest lectures at universities in India and abroad, and writes extensively on admiralty law reforms. Known for his pragmatic advice and sharp advocacy, he has mentored a generation of shipping lawyers and continues to shape India's maritime legal landscape with vision and commitment. Shri Majumdar, we invite you to kindly address the gathering.
Good morning. Can you all hear me? Yeah? Honorable Justice Shyam Kumar, dignitaries on the dais, guests, ladies and gentlemen, and my dear students. It is truly a privilege for me to speak at the Maritime Law Summit 2025, hosted by Vinayaka Mission Law School. I thank the organizers for inviting me to be part of the occasion, and I extend my warmest greeting to everyone present. What makes this event more exciting is, of course, sharing the dais with Justice Shyam Kumar, with whom I, along with my colleagues at Bose and Mitra and Co., have had the privilege of working before he joined the bench. During the decade of 2000 to 2010, when information on Indian maritime jurisprudence was extremely scarce, a whole host of my juniors and myself at Bose and Mitra would regularly refer to the blog created by Justice Shyam, who was then the advocate, to ascertain his views on legal issues in the shipping industry. The legal fraternity at large benefits when an academic scholar joins the bench, as that adds a certain amount of academic scholar rigor in relation to judgments that are then cast in stone. Incidentally, Justice Shyam Kumar has come out of the same chamber as Justice Thomen, who we consider to be the grandfather of Admiralty, because he is the one who extended the jurisdiction of Admiralty through his judgment, the MV Elizabeth, to all the coastal high courts. So till 1993, and I don't know if you are aware, of course, because all of you are going to join the profession in the era of the Admiralty Act, which already gives all the high courts jurisdiction. But till 1993, from independence till 1993, it was only the high courts of Bombay, Calcutta and Madras which would only exercise pan-India Admiralty jurisdiction. The other high courts would only exercise jurisdiction which was given to them under the Merchant Shipping Act. It was the judgment, the landmark judgment of MV Elizabeth, which opened the doors of all the coastal high courts to practice admiralty law. And I think since then there has been no turning back. And I'm very proud to say, because one of the things that we have in our chamber over the last 20 years, and I have had juniors who've gone up to becoming associates, senior associates, from all the coastal states. And a lot of them have now gone back to their home states and are practicing admiralty law in those states. And I'm very proud when I go to those courts and see them practicing either as my opponent or as my colleagues. And at least that gives me a great sense of pride. Of course, I should not miss by saying that Mr. Justice Sham also hails from the chamber of Mr. Venkateshan, who was one of the most prominent pioneering senior lawyers practicing admiralty law. I think he was probably in that era what we call the person everyone looked to get advice on shipping. He's taught me a lot as well. So, yes. So over the decade, Indian courts have evolved their own jurisprudence rather than following courts, the only English precedents. In fact, in the judgment of sea success, and what is important of today's summit is the fact that India as a jurisprudence is slowly creating its own legal system, own precedent on shipping. And we are, till about 20 years ago, perhaps relying on a lot of foreign judgments, but now we are relying on our own judgments which are being created by the judges of our high courts. In fact, way back in 2004, in a judgment of MVC success, the Supreme Court, while dealing with the claim, said, Indian courts do not need to follow the English judicial ideology blindly. We must remind ourselves that in many fields, particularly in matters of preservation of human rights and ecology, Indian courts have gone far ahead than their English counterparts. Currently, we have 8 different high courts exercising admiralty jurisdiction with dockets full. Presently, there are more orders of arrest passed cumulatively by these 8 high courts than perhaps the high courts of Singapore, Hong Kong, England put together. It is but natural that over the next decade or more, we will witness the evolution of maritime jurisprudence on a number of legal issues where Indian law is at its nascent stages of development. We at the Admiralty Bar are waiting with bated breath to read scholarly judgments of our judges on a number of issues relating to maritime and commercial law, and I have no doubt that the courts across India would contribute to Indian law the same way as Lord Justice Mustle and Lord Justice David Steele contributed in the development of English maritime and commercial law. The year 2025, this year, is a watershed moment for Indian history, especially for the maritime legislative enactments which have come in. This year, we have seen 5 statutes which have been promulgated by the Indian legislature. We have the Merchant Shipping Act 2025, we have the Bill of Lading Act 2025, we have the Carriage of Goods Act 2025, we have the Coastal Vessels Act 2025, and we have the Indian Ports Act 2025. So there's a whole new jurisprudence which will now evolve out of these new statutes which will be interpreted. Needless to say, there is likely to be a certain amount of teething problem in relation to the interpretation and application of certain provisions, and we would expect that the judiciary can play an active role providing the necessary clarification on the same. Independent India had its first legislation conferring jurisdiction on admiralty courts through the enactment of the Admiralty Jurisdiction and Settlement of Maritime Act 2017, which was created a uniform regime across various high courts in India and repealed many legislations such as the archaic colonial legislations of the English Admiralty Act 1860 and the 1861, the Colonial Courts of Admiralty Act 1890 and 1891, and the respective Letters Patent Act 1865 of the High Court of Bombay, Madras and Calcutta. I mean, today all of you are extremely lucky that you are going to be entering the legal world where there is a domestic law, statute law, which will help you in dealing with things. When we started practice, we had to be looking around and scummaging through different acts to try and see how we would put our client's case within that mold and get out. Under the old regime, Indian courts sought to read into the colonial admiralty legislation provision of various international conventions relating to arrest of ships and apply the same as if the same form part of Indian law. The old admiralty regime in India was fraught with tremendous uncertainties when Indian courts were constrained to cull out Indian admiralty jurisdictions by looking at a milieu of hybrid legislative instruments and contrary judgments of various high courts of India. Consequently, admiralty litigation in India was greatly exacerbated and admiralty courts were hamstrung on being constrained to make determination on rather basic issues which in most other international jurisdictions would be trite law. Take for example the Supreme Court judgment of M.V. Elizabeth, which held that the 1952 Arrest Convention would have the force of law in India, and thereafter the Supreme Court judgment in the Liverpool and London PNI versus Sea Success, which interpreted the colonial courts and said that the 1999 convention would have the force of law in India. The 1999 convention came into force internationally on 1st March 2025, and while the Sea Success judgment was pronounced in 23, during the period between 2023 and September 2011, we were confronted with conundrum as to what extent provisions of the 52 convention would be eclipsed by the 99 convention. It was only in 2017 that our own Admiralty Act came into being and we follow the 1999 Arrest Convention. The need of the hour is to create a synergy between academia, industry, the bar and the bench so that each contributes to the other. Your university has filled this void by setting up the Center of Maritime Law to promote research and academia debate on various aspects of maritime law. This provides exposure to students to extremely niche field of law, which previously very few Indian universities were in a position to offer. In addition to having a career at the Admiralty Bar, possessing a certain amount of academic and practical training in maritime law would open a wide array of career opportunities, such as working in companies within the shipping, logistic, commodity trading, insurance, oil and gas. India has 12 major ports and over 200 minor ports across 7,500 kilometers of coastline, with numerous exciting cases involving various facets of maritime law. Over the next decade, we will not see an exponential demand for lawyers having academic knowledge and practical training in the field of maritime law. Personally, for me, it is extremely heartening to see junior colleagues whom I mentioned working in the law firm, PNI clubs and shipping companies across the world. I must say at this stage that when people say you're doing shipping law and you think, where will my career take me? That shipping law and learning law, anyway, learning any law, any knowledge is good for you. But shipping law doesn't mean that you will become a shipping lawyer or need to practice in shipping law. But that knowledge will certainly give you an advantage if you are looking at jobs in a logistics company, insurance company. And with India growing as it is, and with the government of India's aim to make Indian shipping by 2040 to be the leading, the amount of jobs that will be created in the shipping industry, if you have knowledge of shipping law, it will certainly help. 50% of my ex-juniors today are working in various facets of shipping, not in law firms. They're working in P&I clubs, they're working in shipping companies, they're working in logistic companies, they're working in insurance companies, and of course as lawyers as well. So the field is so vast that learning shipping law does not mean that you have to only practice shipping law, but there is various other facets that you are able to do. What makes maritime law interesting is that it is formed out of amalgamation of various branches of law. You know, when people ask me, what is shipping law? My answer to them is that we are in a parallel world to the real world. Everything that happens in your real world also happens in our shipping world. Why? Because it's a metamorphosis of various branches of law, such as you do the law of contract, you have sale purchase of ships, you have charter party disputes, you have service contracts, you have towage, employment law, you have leasing of ships, chartering of ships, carriage of goods by sea, bailments, you have insurance, marine insurance, pledges. So the source of maritime law includes international conventions, statutory legislation, standard form contracts used in the shipping industry, and judicial precedents. There are extremely few branches of law where international conventions and standard for the industry contract plays such an important role. In fact, our domestic legislations, as there is today as the Merchant Shipping Act, refers to conventions such as the Load Line Convention, SOLAS Convention, STCW Convention, the 1976 Limitation of Liability Convention, the Fund Convention, and many other conventions which exist. Given the international nature of shipping, a maritime dispute involves numerous questions of conflict. What law would govern the underlying dispute? Which court or arbitral tribunal would have jurisdiction to adjudicate the underlying dispute? Whether a limitation fund constituted in a foreign country would be recognized in our country? Whether courts should stay its proceedings in favor of another forum to give effect to the governing law and jurisdiction of the contract? Whether courts should pass orders like anti-suit injunctions, anti-arbitration injunctions to safeguard jurisdiction? A ship may be beneficially owned by a Greek national, registered in the name of a special purpose vehicle, one ship company incorporated in Liberia, fly the flag of convenience in Panama, be manned by Indian or Filipino crew, and be commercially managed by a management company in Dubai. Ships are subject to various regulations, including flag state control, port state control, classification societies, oil major vetting. So the scope is huge. The questions involved are massive. They are not limited to domestic knowledge only. I'm delighted to see such an exceptional gathering of students, scholars, and professionals here today. I encourage the students especially to seize this opportunity and learn from the discussions, ask questions, and engage with the experts. After all, the future of maritime law will be shaped not just by those of us on this stage and over here, but by the bright and committed young minds that you all are. With those words, I warmly welcome you all to the summit. May our deliberations today not only enrich our knowledge, but also contribute meaningfully to the community. Thank you very much.
Thank you, Sri Majumdar sir, for your insights. It is our privilege now to hear from Honorable Justice Shyam Kumar VM, Judge, High Court of Kerala, born on 1st June 1973. Justice Shyam Kumar obtained his law degree from Law College, Ernakulam, and enrolled as an advocate on 7 January 1996. He began his career in his father T. Gopal Kumar Chamber in Thrissur, earned an NLM in Maritime Law from the School of Legal Studies at Cochin University of Science and Technology, trained in the Bombay High Court, and joined Southern Law Chamber in Ernakulam in 2000, becoming a partner in 2005. He established his own practice in 2014, focusing on Admiralty and Shipping Law, Commercial Law and Constitutional Law. An adjunct associate professor at the National Law University of Advanced Legal Studies, he has taught maritime law, law of the sea and marine insurance at several law schools. He was sworn in as an additional judge of the High Court of Kerala on 22nd March 2024. During his tenure on the bench, Justice Shyam Kumar has authored several significant judgments. He has contributed to ruling commuting a death sentence by reaffirming the strict application of the rarest of rare doctrine, cautioned against reliance on photocopies in evidentiary disputes, directed the state to regulate tourism carrying capacity in fragile hill regions, and demanded timely dispersal of disaster relief funding in the wake of the Wayanad landslide. He has also taken a firm stance against frivolous public interest litigations that undermine judicial credibility and clarified limits on tax authorities acting beyond the scope of remand orders. Justice Shyam Kumar is widely admired for his balanced approach to law, his scholarship in maritime jurisprudence, and his growing body of impactful decision across criminal, environmental, constitutional, and commercial law. We are truly honored to welcome you, Your Lordship, and invited you to kindly address the gathering.
Thank you, Stella, for that introduction. I don't know whether I am eligible for those encomiums that have been showered on me, but I should be thanking Stella specifically for reminding me of some of my recent judgments, because I am here more as a maritime lawyer or as a maritime teacher. But Stella reminded me that some of the important judgments that I have rendered are on areas beyond maritime law. She was mentioning about a death sentence matter, just I remembered when she mentioned about it, yes. Thank you, Stella, for that introduction. Respected dignitaries on the dais, my dear students, I am glad to be here. Let me begin by expressing my sincere gratitude to Sharavanan, who called me a few months back and said that I should travel here to Chennai and be here with you all. And I said that who all are here, and I was told that Hari, my classmate and my friend, is here. Raja, whom I know both as a co-counsel and as a lawyer who appears before me, is here. Mr. Julian is here, whom I consider myself my guru in this field, because I remember maybe 2 decades back I had attended seminars where Dr. Julian had been the main speaker. And this was an opportunity to meet Anand, who is from Trivandrum. I never knew that somebody from Trivandrum is heading this institution. And I look forward to see you all, and I would have enjoyed sitting through the deliberations here, but unfortunately I have to catch a plane immediately, so I don't think I will be able to sit through for the seminar session as such. But let me congratulate this institution for inaugurating this Center for Maritime Law. And as Amitava Majumdar was pointing out, there is much future for you, and I congratulate the maritime law students. I was asking Sharavanan, and Sharavanan said that you have a fully dedicated course on maritime law, in the sense that for both LLB as well as 3-year course and 5-year course, you have an elective on maritime law. Incidentally, at the same time, Raja was asking me as to how did I stumble into maritime law, and I said that it was a sheer coincidence. Though I am known as a maritime lawyer and as a maritime law teacher, and one of the reasons as to why I was selected to the bench was because of my maritime background, I should say that I stumbled into the subject, and this was not a deliberate choice at all. So for those students who are here, who have deliberately chosen maritime law, I would say that you have taken the right decision. There's nothing to worry. If at all you have any anxiety or anticipation as to what is in store for you in the future, rest assured, there are very good mentors out there like Raja and Hari who will take care of all the graduates who are graduating in maritime law from different universities, and you will be in safe hands, and the importance of this area is only going to increase. As Dr. Julian was pointing out, nearly 80 to 90% of international trade happens through shipping. And the importance of this area is never going to decrease. And Chennai has had a great history in maritime law and maritime commerce. So this is a safe place for you to be here. I wouldn't say that you should confine yourself to Chennai, but still, maritime law is a good area where you can have a comfortable practice in Chennai, and also the whole world is open up for you once you are in knowledge of this subject, which is almost the same across the globe. I remember when I started practicing at Southern Law Chambers, there is a practice there. Any new junior who joins in has to go and meet the senior most lawyer who had by that time stopped his practice. He was 98 years old and he was at his home. And I went and met him. You might be knowing him, Hari Menon. And he asked me, why are you here in Kochi? Because I told him that I did my LLM in maritime law and all. He said, what brings you back to Kochi? If you have studied maritime law, the whole world is open before you. You can go anywhere and practice. And he told me his story. He said that I started practice in the state of Cochin, because at that point of time, Kerala was not there. Kerala had been split into three because it used to be the Malabar, the Cochin and the Travancore. And he said, I was born in Cochin, which is a very small state. I became a lawyer in Cochin, and the most that I can aspire for was to be a lawyer practicing Cochin, and at most go up till Trivandrum, that is Travancore, and start a practice there. Nothing beyond. But for you, you have the whole world open. Why are you coming back to Cochin? I said that I have my personal compulsions, and so I have to come back. So I'm reminded of this story. I'm just sharing it with you only to tell you that this area that you are now studying is capable of opening up to you vistas of knowledge. You needn't even confine to this area, because this is an area that would even take you. Because another aspect about maritime law is a kind of a superstructure that has been built on a foundation which comprises of the entire gamut of commercial laws. So any student of maritime law who wants to acquire a complete knowledge in this subject has to have a thorough foundation on all the important aspects of commercial law generally. So unless you know contract law and the Contract Act threadbare, the Sale of Goods Act, the international law, public international law as we know it, the private international law, the insurance law, tort law, and unless you have a good foundation in these areas, you won't be able to construct the superstructure of maritime law. And that exactly brings me to the next point, which Mr. Julian was pointing, the relevance of having a center like this one, which is exclusively confined to the study and research into the area of maritime law. Again, Raja was pointing out the importance of 2025. You have at least half a dozen new statutes that are coming out in 2025. What would you students do with respect to these statutes that are coming in? How would you study it? What do we as judges expect a center like this to do when new statutes are being made? We expect a center like this to study the law, point out where these law would need fine-tuning. Are these statutes capable of meeting the felt necessities of the times? For example, one statute that Raja mentioned is the Indian Ports Act of 1908. 1908, mind you. Prior to that, you have the Bills of Lading Act 1865, Raja? 1855. You have the Carriage of Goods by Sea Act 1925. All these statutes are being updated now. What do you mean by updation? Is it the old wine in the new bottle? Or is it updated so as to take care of the felt necessities of these times? Like for example, we live in an era where the Hague rules, the Hague-Visby rules, the Hamburg rules, and now we have the Rotterdam rules. We have the Multi-Modal Transportation of Goods Act of 1993. In 2025, when we are making a new law, as students, why don't you check up the new statute book that has been now made out and compare and contrast it with the international conventions and see how far we are equipped to deal with situations that might crop up in the future. Are we updated enough? Or is it the old law getting a new name or a new year at the end of it? I know that today's discussion is on charting the course of cargo contracts and claims. We have experts here who would be addressing you in detail on charter parties and the intricacies of these issues. Since I have maritime law students here, let me just put a question to you, not a very simple one. How many here have heard of bill of lading? Just raise your hands. Very good, very good. I should congratulate Saravanan, I guess, because he is your teacher. Bill of lading. And charter parties. How many know about charter parties? Very good. Almost every hands are up. I can see that you are all good students. What is the difference between a bill of lading and a charter party? Is there any difference? Is there any similarity between them? I remember my professor when I took my post-graduation in maritime law in 1998. I think most of you would not have been born at that time. In 1998, I was told by my professor Dr. A.M. Varki, who was a doyen and a great expert in maritime law, that unless you understand the peculiarities of maritime trade and commerce, and you understand the difference of the different kinds of contracts that people enter into for the purpose of transporting goods across the sea from one place to another, there is no point in going straight away to Hague rules and Hague-Visby rules or Hamburg rules. I realized this to be a true thing because subsequently when I started my teaching career, I had to teach international trade students at the National University for Advanced Legal Studies. They were doing their LLM. So they have completed their LLB, they are doing their LLM, they are specializing in international trade, and they had one paper on marine insurance. Marine insurance. I'm sure that you will be having a paper on marine insurance too. No, only carriage of goods by sea. All right. So, international trade, they were all experts. You ask any of them any question on WTO, they will answer. GATT, they know everything. So before starting my classes on marine insurance, I used to ask them a simple question. What do you think is the most important documents in international trade? One is the bill of lading. Yes, yes please. Bill of lading, very good. Second document, which you think is the most important one, which is the bedrock on which the international trade works. Bill of lading, you are right. Sorry? Contract of sale, good one. But there is another document. I will give you an example since I have some time. Think of a situation where somebody from Chennai wants to sell one container full of a local produce. Let us say the handicrafts that you make here from Pumpuhar. One full container load of handicrafts from Pumpuhar to United States. The seller is ready here with the container. The whole cargo or the stuff costs, say 50 lakhs. He would call up and say, send me the 50 lakhs, I will see to it that this container is placed on board a vessel. The American would say, the buyer would say, I cannot send you the 50 lakhs now. You send me the goods. Let me look through it. once I receive it in my custody, I will give you 50 lakhs. So the seller is ready to sell, but he is not ready to part with the cargo unless he gets the money. Buyer is ready to buy and he will pay, but he won't pay unless he gets the custody over the goods. There is a stalemate. How will international trade happen? How will it take place? What do you think is the way out? Is an issue of payment, isn't it so? Let me see how the students here are thinking. Bill of lading is already there because he is ready with bill of lading and he will part with the bill of lading provided the money is paid. Bill of lading is a title to the goods. Yes, please. Charter party agreement. Charter party is also perfect because you don't have a problem. Charter party agreement is there. Essentially, what is a charter party agreement? Yes.
Charter party agreement with the proper Incoterms, which is
Charter party agreement with, thank you very much, sir. Thank you. Charter party agreement with proper Incoterms. So what exactly is a charter party? Essentially with respect to a contract for the purpose of transportation of goods. But our problem is regarding payment. Sir, the problem here, both of them, they have this stalemate. We call it as a catch-22 situation. Seller is ready to sell, buyer is ready to buy, but they cannot do it because that payment part is stuck. What do you think is the way out? Which would be the document that would come in and play a great role? Beautiful, correct. Letter of credit comes in.
LOC.
LOC, very good. What is a letter of credit? So, as maritime law students, will it be complete for you unless you know something about letter of credit? Letter of credit is a document that may not directly have any relevance to the carriage part, but it assumes relevance. Unless you have a letter. What is a letter of credit, by the way? Anybody? Yes, sir.
The letter of credit is actually that seller is ready to sell his goods. Buyer has to give a letter of credit to the seller. So through the banking.
Correct.
So most of the shipping transactions happen through banks. So nobody has a ready cash on this. So bank has given the LOC, letter of credit to the seller. So based on that LOC, seller has to give sell his goods. So
correct. So it's a simple process. Thank you. The buyer would say, we have a problem of trust. We have to make the payment. I will do one thing. Let me know the name of your bank in Chennai. So he would say, my bank in Chennai is SBI, Mount Road branch. So his bank would contact the local branch here. They have an arrangement. Letter of credit means it's a letter which says, which is issued by the bank, which says, this man is credit worthy. That is all. He has this 50 lakhs with him because his credit is not our concern. The seller here is only concerned about getting his 50 lakhs. Whether he has 1 crore, I don't want to know. I just want to know whether he has 50 lakhs. So the bank of the buyer informs the seller's bank that, yes, this guy has 50 lakhs and his 50 lakhs is lying with me. Once this bill of lading is transferred, immediately the amount will reach the account. So before the ship moves out from Chennai port, the amount is there in the bank of the seller's account. So for a businessman, he gets to roll the money. Before the cargo reaches there, he gets the money. So these are all practical things that we need to learn before we go into the intricacies of a charter party. Essentially, coming back to the earlier question, how is a charter party different from a bill of lading? I would take that answer from somebody from this side. How is a charter party different from a bill of lading? Or are they similar? Anyone? Think of a situation where, in our own example, that single container of Pumpuhar handicrafts to America. I don't require a ship to transport one container. It's only one box. I require some space on a ship where I can keep this box. So I'm taking out just that space from the ship owner for transportation of this container alone. The entire ship and the other parts of it, I am not concerned, because the ship is going, other people can take out the space. So if I have, I'm just giving you a simple example. So bill of lading is issued essentially, not always, but for the purpose of easy understanding, when you have to transport a small quantity of goods and you place it on board the vessel and you get a bill of lading. What is the meaning of a bill of lading? Many of these terms will give you the meaning or what it stands for if you look at it literally. Bill is a paper of what? Lading. Lading means what? Lading or keeping on board the vessel. So once you keep this goods on board the vessel, he gives you a paper. And this paper is not a simple paper. It has three essential attributes. What are the three essential attributes of a bill of lading? Very good. Very good. Title?
It's a negotiable instrument.
Negotiable instrument. Which is the third one? Title? Negotiable instruments, yes. Very good. It's an evidence of contract of affreightment. Sharavanan, you have done a good job. These are the three essential attributes of a bill of lading.
Sir?
Yes, you have the mic, sir. Please. I think you have to switch it on.
We are elected this subject based on because of surrounding.
Very good, very good.
That is why.
You are in safe hands. So, bill of lading has essentially these three attributes. It's a document of title, or rather, to start it off, it's a receipt. It's a receipt which says that the goods have been received on board. Secondly, it is an evidence of contract of affreightment. What's your name, sir?
K. Balakumar, sir. Balakumar.
Yeah, as he contract of affreightment. Thirdly, it is a titular document. What do you mean by titular document?
The receipt holder have the full rights of the document. He can sell the goods even using the bill of lading as well.
Yes,
Before
it is a titular document that the ownership to the goods. We call it in legal terms. We cannot use it in the usual terms that the people would say. Property in the goods would transfer from the person to person depending on the bill of lading being handed over from one person to another. I remember during those early times when I joined Southern Law Chambers, we had a old litigation which is the MV Indian Grace, where the bill of, I don't know, are you aware of the MV Indian Grace decision on Admiralty jurisdiction? It's a House of Lords decision of MV Indian Grace, where cargo comprising of howitzer guns, the shells and cartridges for howitzer guns was being transported from France to Cochin. I remember reading the bill of lading because the case was conducted by my office. And on the reverse of the bill of lading, what would you see on the reverse of the bill of lading, incidentally? Have you seen a bill of lading?
The NDRC. NDRC.
Sorry?
NDRC.
I'm sorry, I didn't get that.
Endorsement.
Endorsement, yes. But on the reverse of it, you see tiny typed words and sentences which are the words, conditions based on which the bill of lading has been issued, isn't it so? Terms and conditions of carriage. So, endorsement, as you rightly said, each time this bill of lading changes hands from one person to another, I hope my time is not up. Please remind me. The endorsement would be there. What does this endorsement stand for? On the reverse of the bill of lading, if you take an old bill of lading, we will understand the number of times it has changed hands from one person to another, looking at the endorsements on its reverse. What is an endorsement? Usually it comprises of a seal and a signature.
So bill
What
of,
does it stand?
so bill of lading actually is a transferable. So it's a being a negotiable instrument, it can be transferred.
That exactly is what is meant by a titular document. We are not on that.
I'm not talking about the bill of lading without transferring the goods. Bill of lading alone can be transferred one party to one party. Sale. You can sell the bill of transfer.
Precisely.
bill
You're
lading
right.
By transferring that. So for that, the reverse of the BL, so we can be endorsement to one party to other party, which is a sale transaction.
That is essentially a part of titular document. That's what we meant when we said it's a titular document. How is a charter party different from all this? Because today you are going to have a discussion on charter parties, not on bills of lading. And we have experts here who would be explaining to you what charter parties is. How many charter parties are there in terms of categorization? Anybody? The types of charter parties as we call it. I am sure that you have in your library Carver on carriage of goods by sea, Scruton on carriage of goods by sea, or Scruton on bills of lading, which is a new edition. And how many types of charter parties are there? Yes, ma'am. You can use the mic. Let us all hear. Let Sharavanan be proud. Voyage charter party.
Charter party. Bareboat charter party.
Bareboat.
Device bareboat charter party. Demise bareboat charter party.
Demise bareboat charter party. Very good, very good. Excellent, excellent. So, bareboat charter party and demise charter party are essentially one and the same in a sense. We will come to that. What is a voyage charter party and a time charter party? It's very simple. Charter party for the purpose or taking out the vessel on charter for a particular period of time is a time charter party, and for a period of for a voyage is a voyage charter party, essentially in the most simplistic way. Do you think that the terms and conditions of these two charter parties would be different from one another? And then if they are different, in what terms? One is a situation where I have a whole load of cargo to be transported on a vessel, so I cannot take a bill of lading. I want a huge vessel itself for transporting my entire cargo. So I go and take the vessel on a voyage or a time charter, depending on my requirements. If I require it for a period of 1 year, say, I would go in for a time charter party. If I require it for a single voyage, I would rather end up doing a voyage charter. These are all simplistic and the most simplest concepts. That's all. It has its own complications. There are hybrid charter parties. We will come to that later. What exactly do you think would be the difference between a voyage charter party and time charter party? Anybody? Maybe you haven't reached to that advanced levels in your classes. I don't know. You will go there. You will reach there. Just look at it from the common sense point of view. How would a voyage charter party be different from a time charter party? Yes, please. Please pass on the mic. Please pass on the mic. Correct. Precisely, you're right. Very good.
It doesn't consist of a single voyage journey. It may be return journey or it may take around a time. So there is no type of single voyage in a time charter party.
Very good, very good.
It can be moved to one port to another if they need to move.
Very good. Exactly. Now the question is, how would they be different? Or what all would be the terms of difference? Just commonsensical, logical point of view. We don't have to study this. If I am taking a vessel for a period of time, then who is going to fill the fuel? If I am taking it out for a period of 1 year, do you expect the ship owner to pay or to fill on the bunker for this entire period? Because he doesn't know how much I would be using it, what would be the schedule. So at least, just to give an example, the bunker liability would shift on from the ship owner to the charterer, because I will have to fill in the bunker. I'm just giving you one example. Whereas in the case of a voyage charter party, for example, it's a transportation from Chennai to Colombo, maybe. It's a single voyage. The fuel is the responsibility of the ship owner. He has to provide me a vessel, and the service of the captain and the crew would be that of the ship owner generally. It could be the other way in the time charter party also. But the point is this, all that I am trying to convey in this brief time is, there is essentially differences between these two charter parties. And in the case of a demise charter party, I think it's you who mentioned about demise charter party or a bare boat charter party. What is the essential characteristic of a bare boat charter party? Anybody? What do you mean by bare boat?
Sir?
Yes, please.
The ship is delivered.
Yes.
The ship is delivered to the charter party for a long period of time in a bareboat charter party.
You are right. But
in
what do you think would be the status regarding the crew and the captain? When I am taking a vessel for a period of 1 year, either the ship owner can provide the crew and the captain, or I can keep my own crew or the captain. I am sure that in the afternoon session you will be taken through the intricacies of it in a much better and more beautiful way than what I am doing now. A demise charter party or a bare boat charter party is a charter party wherein the vessel alone is given to the charterer. The vessel demises on the charterer, and he might have the lookout so as to keep the crew members. Employment of crew members might be the lookout of the charterer in such situations.
It depends upon and all.
You can just hold it a bit higher.
It depends upon the charterer and the ship owner obligations.
Precisely, it depends on the terms and conditions. You are right. So, I'm just flagging some of the very basic aspects which I would request you to discuss and deliberate, since you have this Center for Maritime Law. I wish all of you all the best, and I wish this center all success. Thank you.
Thank you, Your Lordship, for sharing your insights. To conclude the inaugural ceremony, I invite Mr. Saravanan, our Assistant Professor of VMLS, to deliver a word of thanks.
A grand event like this is possible only through collective support and encouragement of many individuals and teams. On behalf of Vinayaka Missions Law School and as a faculty coordinator for the Center for Maritime Law, it's my privilege to deliver a vote of thanks for this inaugural ceremony. We deeply honored to thank our Chief Guest, Honorable Justice Shyam Kumar Sir, Kerala High Court, for graciously accepting our invitation and inaugurating the Center for Maritime Law despite its demanding schedule. A special thanks to Sri Amitav Raja Majumdar, Managing Partner, Bose & Mitra and Company, for addressing his inaugural ceremony with his valuable insight and for also joining us as a distinguished panelist in the Maritime Law Summit. Our sincere appreciation goes to Dr. A. Francis Julian, Senior Advocate, Supreme Court of India and Honorary Chairperson of the Center, whose visionary guidance has been a beacon for this initiative. We also thank our distinguished panelists, Captain Pankaj Kapoor, Advocate Harinarayan Sir, Dr. Moghat Gupta Sir, Shri Debesh Mukherjee Sir, for joining us today for their forthcoming contributions to the panel discussion that flows this inaugural ceremony. I extend my heartfelt gratitude to Dr. Anant Padmanabhan, Dean of VMLS, for his inspiring leadership and unwavering support which has made this occasion truly memorable. Our heartfelt thanks to Dr. A.S. Ganeshan, Chancellor, Vinayaka Mission Research Foundation, for his continued vision and blessings that have shaped every initiative at VMLS. We are also grateful to Dr. Anuradha Ganeshan, Vice President, whose active engagement and leadership have inspired our institutional growth. A special note of thanks to Mr. J. Suresh Samuel, Strategic Officer, for his support and encouragement throughout the planning and execution of this event. My sincere appreciation goes to my faculty colleagues whose constant support for this invaluable event, and particularly to Dr. Fomina, Associate Dean, Professor Mike Rubin, and Professor Krishna Kishore. We also thank Mr. Victor, Director Administration, for his support in ensuring smooth execution of today's program. I would also like to thank Mr. Kalai, Manager, for his constant support. A heartfelt shout out to our Media Outreach Committee and a live streaming people, the invisible force working behind the scenes to ensure presence was vibrant and visible online. Our gratitude goes to our housekeeping team for their silent yet crucial role in keeping the campus clean and welcoming. And also I would like to thank Mr. Karthik Raja, Facilities Manager, for efficiently overseeing stage setup, transport and decoration. We also appreciate Mr. Chinna for providing seamless technical and IT support, and also the sound service team for the flawless audio arrangements. A special note of gratitude to Mr. Rajesh, General Manager of VMCC, for his continuous support, and bouncers for ensuring safety and smooth crowd management. I also thank the security for maintaining the overall order with quite efficiency. Last but not the least, our student volunteers and the participants who are here, who deserve a resounding round of applause. Your dedication, enthusiasm and behind the scenes effort ensured that every part of this event ran like a clockwork. And to anyone I have unintentionally missed, please accept my sincere apologies. Your contribution, whether on stage or behind the scene, is truly valued and deeply appreciated. Thank you all once again for making this event a resounding success.
Thank you, Mr. Saravanan, for your kind words. With this, we conclude our inaugural ceremony. Lunch will now be served at the Moot Court Hall. We shall reconvene at 1:30 p.m. for the afternoon panel discussion. Thank you, everyone. Students, kindly wait until the guests leave.
ونوسلي هدسيني هدسيني ونوسلي هدسيني هدسيني ونوسلي هدسيني هدسيني هناويلي عناويلي عناويلي ونوسلي هدسيني هدسيني ونوسلي هدسيني هدسيني ينصر مخني ولي منبوط سر النهني منبوط سر النهني ينصر مخني ولي هيا هيا ينصر مخني ولي ينصر مخني ولي عنا والهي عنا والهي عنا والهي ونوسلي هدسلي هدسلي ونوسلي هدسلي هدسلي ونوسلي هدسلي هدسلي عنا والهي عنا والهي عنا والهي ونوسلي
check. 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 Check this.
Good afternoon, ladies and gentlemen, and welcome once again to the Maritime Summit 2025 to the today's most awaited panel discussion.
Our discussion today, titled Maritime Summit 2025, Charting the Course for Cargo, Contracts and Claims, focuses on cargo claims under the Admiralty Act 2017, the intricacies of charter party contracts, the status of bills of lading, and disputes over demurrage and misdelivery. I am pleased to introduce our esteemed panelists. Captain Pankaj Kapoor is the managing partner at Quadrant Legal. Captain Kapoor is an ex-ship captain turned lawyer and the founding partner of Quadrant Legal. He has served on Niti Ayog's National Maritime Policy Committee, sits on the advisory board of India's first International Maritime Arbitration Centre, GIMAC, and is on the Skill Development Committee of the Delhi Management Association. A master mariner with law degrees, he has been part of high-powered government committees and has resolved disputes for domestic and international clients. Captain Kapoor has more than 2 decades of experience handling charter party disputes, salvage and demurrage claims, marine insurance, ship arrests, and matters under the Maritime Labour Convention.
Our second panelist, Advocate Hari Narayanan. Advocate Hari Narayan, partner and maritime lawyer, United Maritime Law Chambers. Advocate Hari Narayan is a pioneering maritime lawyer and partner at United Maritime Law Chambers in Cochin, with an overseas office in Hong Kong. His firm handles both wet and dry shipping matters, including ship arrest and maritime arbitration. He serves on the Governing Council of the Maritime Law Association of India, is a supporting member of the London Maritime Arbitrators Association and the Singapore Chamber of Maritime Arbitration, and teaches at the Indian Maritime University.
Our third panelist is Sri Amitava Raja Majumdar, Managing Partner, Bose and Mitra and Company. Mr. Majumdar founded a Bose and Mitra company in 2004 and has grown into one of the India's most respected shipping and admiralty law firms. His expertise span contentious and non-contentious aspect of shipping and trade and various regulatory practices and policy making. He appears before the court, Supreme Court, various high courts and arbitral tribunals, and provide expert evidence on Indian law, and also procedure before the English High Court and Singaporean courts. He is a leading practitioner in ship sale and purchase transaction, and also represents Indian ship owners and association worldwide, and advises ship owners, charterers and other commodity traders, PIN clubs and government bodies. He helped the draft the Admiralty Jurisdiction and Settlement of Maritime Claims Act 2017 and draft the Merchant Shipping Bill, served on the India's delegation to IMO Legal Committee, and is consistently ranked as a band-owned shipping lawyer by Chambers and Partners and Legal 500.
Our next panelist for the day is Dr. Mohit Gupta. He is an assistant professor and the head of Center for Research on Maritime Labour Law at Gujarat Maritime University. Dr. Gupta leads the Center for Research on Maritime Labour Law at Gujarat Maritime University and serves on GMU's Board of Management and Board of Studies and is part of the research team for the GMU International Seafarers Welfare and Assistance Network. A UGC NET scholar with a BA LLB from NLU Lucknow and an LLM in International Law from South Asian University. His specializations include the law of the sea, maritime labor law, admiralty law, and public international law. He has published on topics such as the role of admiralty codes in protecting abandoned seafarers, presented at international conferences, and received fellowships from the Korean Maritime Institute and the United Nations. Dr. Gupta is also a sought-after guest speaker at universities across India and abroad.
Our next panelist is Sri Debashish Mukherjee, a manager, legal, Synergy Maritime Private Limited. Mr. Debashish is currently serving as a manager in the legal department of Synergy Maritime Private Limited. Before transitioning to the shore-based career, he sailed as a chief engineer on merchant marine sales, and after obtaining his LLB degree in Calcutta, he briefly practiced at the Airport District Court in Calcutta. He joined the Synergy Group about 12 years ago when the company managed just over 40 ships, and he has been an organization ever since. During this period, Synergy has grown into became the world's second largest ship management company and as per Loyal's list, managing more than 700 ships worldwide. Over the years, Mr. Debashish has worked with various other entities within the group, gaining an insight into multiple facets of the ship management business, and it's also associated a legal risk while continuing to nurture his passion as a proud of student of law. And today panel discussion is moderated by Mr. Saravanan Ravi, Assistant Professor, Faculty Coordinator, Center for Maritime Law, at VMLS. With the distinguished guest and our moderator now introduced, the panel is open for the discussion.
Thank you, MC team. So good afternoon, ladies and gentlemen. On behalf of Vinayaka Mission Law School, I extend a warm welcome to all of you today for the panel discussion on chartering the course of cargo, contracts and claims. We are privileged to have with us eminent panel of industry leaders, distinguished lawyers, scholars. I assure the insight shared today will be invaluable for practitioners, students, and stakeholders in the maritime and shipping sectors. So straight away to set the stage, I would like to start with Sir Debashish Mukherjee, sir. So for the benefit of broader audience, would you briefly explain the significance of ship management in modern shipping?
Hello, I hope I'm audible. Actually now, for last, I would say, 4 decades or so, the core shipping used to be, before that, the shipping used to be by ship owners. Or the company who owns ship, they will be running the ships. Then gradually, as the companies grew and the regulations came in, variety of regulations started coming in. It was becoming difficult for every ship owner, even smaller or bigger, to have all kinds of expertise be maintained within house, because they are ship owners. It's already a capital intensive business. A lot of money is required, and they cannot have all kinds of expertise within the, within one roof. So that's when the concept of, actually it's a very old concept, but then it started getting momentum around 80s or so, last century. And now it is greatly. So every small and big ship owner would like to put their ship into some ship management company. Now what is ship management company? Is like for example, we get a truck. So if I have to get a truck and I have to run, then better I be a driver. I have my license. I arrange my cargo and deliver from point A to point B or whatsoever, like that. But when I have to get 2 trucks, then I have to get 1 more driver. I have to manage him. I have to run my show. So, and then if my business grow, I'll get another truck. I'll put 1 more. Then I have to manage 3 and so on. So gradually it becomes difficult. So what is then preferred? And for shipping, it's almost like that. That means we would like to, we just cannot have a ship purchase a ship, I may have money, I get a ship, and then I have to trade the ship. So for trading the ship, it's not just like getting a truck and running it. So we have to have the expertise. That means first thing we need is to have the document of compliance which is issued by the flag of convenience, means the country where it is registered. So they will issue the document of compliance. Compliance in the sense, is my company or the vessel satisfied all the regulatory requirements or not? So according to that, that will be done. So what then happened is that this ship management business came into picture. So a ship owner will buy a ship and then give it to them. And then once they have the ship, once it comes to the ship manager, then ship manager is responsible for taking care of all the regulatory requirements. Then they will also ensure that a crewing is done. Efficient crew, competent crew is put on board. They will also ensure that the vessel is maintained at all times. Vessel integrity, seaworthiness, that is maintained. So now gradually this is shifting towards ship management. So there are many ship managers, and worldwide ships are being purchased, given to them. There are the ship owners who are, like in India we have Great Eastern, SR, they still maintain their own ship management within themselves, and many of the owners do also like that. But then they have segregated their ship management division, because ship management focuses purely on the management of the vessel. That's like a complete package, from licensing, all kinds of regulatory compliances, putting right manpower on board, then moving the vessel, doing everything that is required, and also assisting the owners whenever there is any kind of a dispute between charterer and the ship owner. So like that it is. So it's a very successful model. So that used to be there. Now, recently of late, I would say for last few years, even ship manager and ship owners are getting into joint venture. So that means ship owners also want to be a part of the ship management. They also want to have accountability onto that, and also have a checks and balances into the ship management business on the ship manager. So that's how it is going, and it's a very successful model in today's business. So bigger players, small players, means ship owners, are going for ship management business.
So to follow up, so like in your experience, what are the common disputes between the ship owners and charterers?
See, when I talk, I will speak from the point of view of a manager that we see, because very common is from the charter party related disputes will come, because charterer and owner is bound together through a charter party agreement. So ship owner has given the vessel in one of the charter parties that Judge Shyam just explained some time before. So what happens? There are three types of charter: either void charter, time charter, or bareboat charter. Now, depending upon the charter, type of charter that we have with the ship owner, the dispute will arise. The dispute that commonly is seen is related to cargo, which is heavily there. Most of the disputes is because of the cargo related matters. Then there are disputes related which is arising from, or you can say the core of it lies with the new regulation of fuel, because new fuel regulations have come for which very low sulfur fuel, then low sulfur fuel, then even low sulfur MG, medium diesel oil, medium grade diesel oil will be there. So all that is now coming. Because of that, the traditional ships that we used to have used to run on fuel oil. Fuel oil means the thick oil, the thickest oil. After taking out from petroleum product, after taking out everything, whatever remaining is fuel oil. And then after that lies tar, which is for pitch and all that roads are being built. So fuel oil is just one component before that. So that used to be there. So that means all the engine that used to be built before was to run on that kind of fuel. Now suddenly the regulation said that you have to remove that oil because that is causing pollution. A lot of sulfur is there, and that sulfur is causing the environmental pollution. So that has been removed. So once that is gone, low sulfur fuel has been brought in. It's diesel oil has been brought in. So it's a necessarily we have to run. Now because of that, engines are getting spoiled. And it's like not only engine, during the voyage suddenly the vessel breaks down. The engine breaks down because that low sulfur fuel which was put, which has very less viscosity, it caused more grinding between the parts. Because fuel also acts as a lubricant. Now because of sudden breakdown at the middle of the ocean, now it's a carrying vessel. It's already loaded. So there is a charter party related dispute that will come in, damage related dispute will come in. Then we will reach out to the fuel suppliers because of that. So this is one type of issue that we are facing. Now very off late that we are facing is because of the new regulation of fuel oil that has come. Okay, sorry. So, I think that the sound, if reduced, may help. Okay. So I hope whatever I have told was audible, or I don't know. So, audible, okay. Thank you. So that's the main issue related to the cargo, related to fuel, and new regulations are causing problem with the charterer. And another problem that's seen from ship manager point of view, when we have to manage the ship, is what happens between charterer and ship owner. They enter into agreement with respect to charter party. We are not always privy to that. But we are, say, performance related. That's very common. A vessel is committed to give certain speed at certain consumption. We fail out in that. So that is another.
So now moving on to captain. So from you being in the bridge and to the bar. So charter parties and bill of ladings are basically considered as the vital documents in shipping business. What are the precautions should parties take before entering into charter party agreement?
All right. I hope I am audible. Yeah? No? There was a problem with the volume here. Now it's okay? All right. So charter party is basically a contract between the charterer and the ship owner, and we must ensure that all the possible finer points of the charter party are in place. Like lay time. Lay time is one of the biggest problems we encounter in our court cases right now. Lay time, calculation of demurrage, arbitration. Arbitration is known as the midnight clause. Why do we say it's a midnight clause? The whole day goes on in negotiating the charter party, and towards the end, when we are just about to knock off, that is the time we decide where should the arbitration be. Now, arbitration is a very, very important and a significant part of a charter party. We must ensure that arbitration, jurisdiction, and which courts or which law is applicable to the charter party. These are some very finer points where we end up with having a lot of problems in the charter party. So these are some things we should be very careful about. Once again, I will stress, arbitration is a very important part of the charter party, and it is the most ignored part of the charter party. So one has to be very careful about arbitration and the jurisdiction.
Sir, my next question is to Harinarayan sir. Sir, basically the Admiralty Act does not provide for the arrest of ship to obtain security for an award in arbitration proceedings. Yet Indian courts have upheld such arrest by citing older precedents. And do you think judicial approach in rem enforcement is appropriate, or should an act be amended to explicitly permit those kinds of ship arrest?
Yeah. Am I audible? Yeah. So arrest, as you all know, is regulated by two international conventions. One 1952 Arrest Convention and the 1999 Arrest Convention. Now the 1999 Arrest Convention provides for arresting a vessel to obtain security for your arbitration claim. But when we had our Admiralty Act of 2017, there is no specific provision under this act which permits arrest of a vessel to obtain security for your maritime claim. So there is apparently a lacuna in the legislation which to a large extent is resolved by few decisions of the High Court. The prominent one among that is the decision of Bombay High Court in MV Golden Progress. Of course, that was one rendered prior to the coming into force of the 2017 Act. So though the question was whether you can arrest a vessel for obtaining security for an ongoing arbitration abroad. It was a full bench judgment which held that you cannot maintain an application for arresting a vessel to obtain a security, but you can maintain an application to arrest a vessel only if it is a maritime claim. Now, they also find a solution as regards arresting of vessel pending arbitration, relying on Article 7 of the 1999 Arrest Convention, which lays down a method where arbitrations are ongoing. Article 7 says that if a vessel is arrested and security is obtained, then the parties will have to be relegated to the forum which is going to decide the arbitration. And until such time the arbitration award is rendered, the security that has been obtained will remain with the court, and based on the outcome of the arbitral award, the security amount can be appropriated. So this is a method which has been following by other courts as well. I think there is another judgment in Altus Uber, which was after 2017. But the court actually did not lay down a proposition of law that you can maintain an arrest simpliciter for obtaining security for an arbitral award, because on facts, that case was distinguished, saying that in that particular case, the facts was that it was a maritime claim. And therefore, the court did not go into the question as to whether a suit is maintainable for getting security for your arbitral award. So as things stands now, the Act does not provide for such a method, and hopefully Supreme Court in some judgment will clarify the position that you can maintain an arrest application to obtain security for your arbitral award.
Thank you, sir. So, sir, now I would like to bring Amitav, sir. So, sir, when it comes to arrest of sister ships, basically in some courts I've said that mere common shareholding is not enough to prove beneficial ownership, while others have accepted broader notions. Does this create unpredictability, should Section 5 should be statutorily amended to provide proper definition of beneficial ownership?
The answer is yes. The answer is yes. The statute as it came out, unfortunately the draft which was sent to the Law Ministry in fact had the article as is there in the 1999 Convention, and the 1999 Convention actually very clearly provides about beneficial ownership. Unfortunately, for whatever reason, when the draft eventually went to Parliament, that particular section was not there, and therefore it has been left to judicial interpretation. But as a general rule, and as the Apex Court has also held, in India you cannot have an associateship arrest, unlike in South Africa where you have associateship arrest. Now, what is an associateship arrest and what is a sistership arrest? A sistership arrest is two ships owned by the same company is a sistership arrest. An associateship arrest is two ships owned by two different companies but linked together is an associateship arrest. In India, different courts have been following different practices at the prima facie stage. Now you must understand, when you talk about shipping and arrest, there are two stages. First stage is getting the arrest. That is based on a prima facie case, the best arguable case. The second stage is trial. Just because you get an arrest at the prima facie stage doesn't mean you will be able to maintain it in a trial. And this is where different courts have taken different views. For example, in the Bombay High Court, there is judgments to say that unless you are able to show fraud, or you are able to show that the company A shareholder owns company B in such a way that it is totally interlinked, you cannot lift the corporate veil. You have to leave the ship, the company as it is. Shipping world works on the basis of SPVs. Shipping world works on the basis that one ship, one owner. Unless there is a fraud or you are able to show that link, Mr. X could be owning company A, Mr. X could be owning company B. They each have ship A and ship B. The directors may be common, but you cannot lift the corporate veil to arrest it. However, in certain other high courts, like in Gujarat, for example, there have been cases where prima facie case has been taken that they are beneficially owned and therefore an arrest has been granted. However, if you take it down to a trial ever, you will have to prove that. So in India, unfortunately, we get away with a lot because we arrest and it gets settled. But if it is taken to trial, it may not run the full course. But yes, the answer to your question is the statute needs to be changed and the statute needs to have an amendment put in where this clarity is put in that as a country and as jurisprudence goes, we do not believe in associateship arrest. We only believe in pure sistership arrest. One owner, two ships in the same company.
Thank you, sir. Sir, now I would like to bring Mogat Gupta, sir. Seafarers being the backbone of maritime industry. So when crew members are abandoned, particularly in Indian ports, what are the legal remedies are available to them? And in practice, how effective it is?
Okay. Yeah. So you're talking about abundant seafarer. So first, let us understand what is this abundant seafarer. So Maritime Labour Convention uses this term when a seafarer can become abundant or can be deemed to be abundant. So it says that whenever, for example, seafarer is not receiving wages, so moment his 2-month wages become pending or outstanding, that is the one situation where seafarer can be called as abundant. Moment, there's another 3 situations are there. So second is moment like ship owner has detached all the contacts with the seafarer, not providing the necessities like food, water, food on the vessel, fuel on the vessel, he can again be called as abundant. And thirdly, when the ship owner denies repatriation. So generally, we talk under maritime labor law that seafarers have right to repatriation. For example, suppose the employment contract is for 6 months, then moment the employment contract is over, ship owner have to bring that seafarer back to his country of origin. That is called as repatriation. So, Maritime Labour Convention defines this, like seafarer will be deemed to abundant when any of these 3 situations happens. Now coming to your question, what remedies seafarer have when they become abundant? Now first of all, why seafarer gets abundant first of all? A major problem why seafarer get abundant is sometimes financial crisis faced by the shipping companies. So maybe like there's a big shipping company which is not having enough fund, then it will just abandon the ships along with the seafarer. And those ships might be in different ports in the world, different ports of the world. So what remedies the seafarer have? So first of all, Maritime Labour Convention has understood this problem was existing. So originally Maritime Labour Convention came in 2006, but later on it was amended in the year 2014 and a separate provision was added in the Maritime Labour Convention which talks about financial security system. It's a kind of insurance you can understand simply. So now every ship should have a financial security, which can be in the form of insurance also. 90% of those financial security providers are IG group PNI clubs. So first option which is available to a seafarer who is abandoned is just to go to the insurance company or whatever financial security provider who has given the financial security for covering the to cover in case of abandonment. So under Maritime Labour Convention, financial security provider have to provide the necessities like food, water, fuel on the vessel, and also financial security provider has to repatriate, and also financial security provider have to pay wages, pending wages up to 4 months. So this is the first option which is available to the seafarer. They can find out who is the financial security provider for the vessel on which they are abandoned, and they can approach that financial security provider. Now, other remedies could be going to the Admiralty Court, because when we see, for example, Admiralty Act of India, pending wages is one of the subject matter of maritime claim. So this could be a ground of ship arrest. So there have been many ships which have been arrested on this ground. The seafarers were abandoned and seafarers have arrested the vessel. It has also happened that maybe the vessel was already under arrest. Maybe bunker supplier has arrested the vessel. But later on, bunker supplier has never appeared in the court and he has abandoned the ship. So then seafarers have intervened in the existing Admiralty suit as well. This could be another remedy going to Admiralty Court. Then for recovery of wages, Merchant Shipping Act has this provision like section number 145 where the magistrate court can also be approached if there is a pendency of wages issue.
Thank you, sir. So now, I would like to ask Pankaj Kapoor, sir, a critical question. From your point of view, is the traditional paper-based ocean bill of lading still relevant in modern international trade, or it should be fully replaced with electronic bill of lading?
Right, thank you. Well, yes, traditional paper bill of lading is still very much used because the banks still trust them, and the electronic bills of lading, a number of countries have not yet ratified something is called as UNITRA's MLETR guidelines. There are only 3 or 4 countries in the world who have accepted MLETR. One of them is Singapore, UK. I think 2 or 3 more countries have accepted. So banks have not as yet accepted. Even India is in the process of accepting electronic bills of lading. That's number one. Number two, there are a couple of platforms available like Bolero, just for the benefit of the candidates, of the students here. Bolero is Bill of Lading Electronic Registration Organization. So Bolero is there, ESS Doc is there, but the problem with these platforms are that they are not uniform. Now, Bolero may have a certain set of systems, ESS Doc may have another set of systems, so interoperability is still a problem. And that's why banks, traders, exporters, importers, they all accept paper bill of lading because that's a traditional one, and at the moment it is convenient for everybody to accept that.
Thank you, sir. So over to Raja, sir. Sir, with regard to this new Act of Bill of Lading 2025, again it is said that we have come out from the colonial legislations, but still the Act doesn't recognize this electronic Bill of Lading expressly. Do you think, what's your take, should it be amended further to include expressly?
Yes, unfortunately, I'm a little disappointed with the Bill of Lading Act and the Carriage of Goods by Sea Act. We've done a comparative study of both of them, and other than the year being changed from 1855 to 2025 and 1925 to 2025, the Bill of Lading Act and the COGSA remains verbatim the same, identical, same words. The only addition is that the government has now got powers to make rules. It was in fact said in the parliamentary question when Minister actually said that the question arose of electronic bills of lading, and the Minister said that there would be a new act which would be promulgated for electronic bills of lading. That is what they actually said on the electronic bills. But I would imagine that when the Bill of Lading Act was amended, there should have been a lot of amendments. So in England, we are inheritors of the pre-colonial laws. So we have the Bill of Lading Act 1855, and so did England. The English Bill of Lading Act is also called Bill of Lading Act 1855. In 1992, the United Kingdom amended the Bill of Lading Act, and it came out as Carriage of Goods by Sea Act 1992. In the UK, they call all shipping acts as Carriage of Goods by Sea Act, whether it be dealing with COGSA, or whether it be dealing with Hague-Visby rules, or whether it be dealing with bills of lading. When they did that, they actually changed the law. So one of the things which is very, very important in India is under the 1855 Act, a bill of lading is a title document. But the title to sue, and that is what the 1855 Act dealt with. It's a very short act of 4 sections. And it deals with title to sue. And it says every consignee or endorsee of a bill of lading. In fact, I have argued a case before the Madras High Court, which is the leading case on this, where the court held that because he was not an endorsee when he filed the suit, he had no title to sue, and therefore the arrest was held to be wrongful and the ship was released. Now, in modern day parlance, you don't get the bill of lading come in that quickly. Now, if in the morning session, you remember, Justice Sham was talking about letters of credit. Now, letters of credit are basically forms of payment for your trade, but they also form a type of a loan facility because it's deferred payment. So, letter of credit may have that the payment will only be made after 30 days or 60 days. Now, in 60 days, the ship would have reached the port of discharge and will need a bill of lading, right? But in practice, the bill of lading never reaches the port, which is why in practice, you have cargo being discharged against what we call an LOI, letter of indemnity, where the cargo owner comes and says, I haven't got the bill of lading, please give me the cargo. I say that I am going to become the bill of lading holder, and if it goes wrong, you sue me. Because the LC documents, which include the bills of lading, are sitting with the bank, and the bank will only hand over those LC documents when it is paid by the buyer who has a 90-day credit with the bank, and the bank will pay it after 90 days. Now, to circumvent this, when the English Act of 1855 was amended, they included not only an endorsee and consignee, but they also included what was called holder in due course, which means the bill of lading is going to be endorsed to me. I will become a holder of the bill of lading in due course after the, but I still have a right to sue, the title to sue. So those amendments, which didn't exist in 1855 because the bills would have been hand delivered sometimes, which are now modern day realities, should have been looked at when the Bill of Lading Act was amended to give more business efficacy. Because as of today, if you want to go to arrest a vessel because you are a Bill of Lading holder, the first thing that we ask is there an endorsement or is it a straight Bill of Lading? If he doesn't have title to sue. The shipper could sue, the bank can sue, but not the receiver.
That's great. Thank you, sir. So over to you, sir, Devesh sir. So when it comes to e-bill of lading, how far like shipping companies or ship managers are equipped for it? So whether it is possible for a shift from the ship manager's point of view, what's your opinion on that when it comes to e-bill of lading?
Yeah, so as Raja has said, like bill of lading, now let me tell you a scenario. We have consignor who is going to give the cargo on board, put the cargo on board, then issue a bill of lading. Bill of lading will be issued with the basic requirements, elements within that. That is the type of cargo, quantity of cargo, and all the descriptions will be there. And then it will be issued. But there is a catch from the ship owner side also, which is from manager side and from the crewing side. We need to see is the mate's receipt. That means what is the actual quantity received on board. Now, bill of lading may have some quantity specified into that, but when it comes on board, we have the, it is measured because ship is a floating body. It will be going down, so much is loaded. So that draft and then calculation. Then we get the value, how much loaded. So with that, in the mate's receipt, which is the receipt which is issued by the master, that so much is issued. Now, if there is a difference between that, and that happens, where, like some countries in, say, Canada, they say that whatever cargo passes through the customs weighbridge, that like truck passes through weighbridge, for tonnage certificate, like that, a tonnage certificate is issued for the cargo passing from the customs gate. So as per that, the bill of lading will be numbered. There's so much cargo loaded. But what we receive on board, instead, may be less. Now, when it is received less on board, we would like to put that amount. How much quantity received on board? Now, what the customs say, if you put a remark on the bill of lading, because if we do not put a remark, it becomes a clean bill of lading. And clean bill of lading is always required, asked for by the customs and the parties. They won't allow any remark to be put into that. Means master cannot write so much quantity less, so much quantity received. Because the moment he puts something, it becomes a remarked or marked bill of lading. Now that is when the dispute starts cropping. Now what the other party will say, the charterer, I will issue you a letter of indemnity. As he said, letter of indemnity is issued. Now letter of indemnity, the charterer will say, the shipper will say to the charterer, okay, we will give you a guarantee if there is any issue. So the charterer then approaches the owner, say that we will give you a letter of indemnity if anything happens, if any suit is filed against you as a owner for the discrepancy in the cargo, we will help you. Now the question arises, who is the charterer? What is his financial credibility? Okay, because the cargo may be of hundreds and thousands of dollars, maybe millions of dollars. So what is the credibility of the charterer issuing that letter of indemnity? Because he says that if anything goes wrong to the owner, because of that bill of lading, I will compensate you. But I need to also understand, does the charterer actually have that capacity to indemnify me? Because many times, some small-time charterer will start a chartering business and will get some consignor to supply somebody in a consignee in some other country. And then the job of a charterer is to connect two parties and the ship owner. Now he got the ship owner, he got a supplier, he got a receiver. Now the supplier has given a cargo which is, as per our understanding on board, we find it less. Charterer says that I give you a letter of indemnity. When the other side, the vessel is supposed to receive it, they find the quantity less, they dispute, and then the dispute arises. Now, basis that letter of indemnity, we may claim. Now, when we start the claim, we may find the charterer may not be in a position to handle it. Okay, because the claim may be large. Sometimes the cargo, it is one situation, there may be cargo related. So these are issues that are often faced by the owners.
So, over to Ari sir. Sir,
adding to what Mukherjee and Raja had said, see, there could be some issues with releasing cargo under a letter of indemnity. Because the legal requirement is that goods can be released only on production of original bills of lading. So to bypass that legal requirement, you are getting into another contract in the form of a letter of indemnity. Now, how do you enforce this letter of indemnity? Because it goes against the legal requirement. I have always had this doubt in my mind.
One more thing I would add up onto that. The moment letter of indemnity is accepted by the owner from the charterer, P&I coverage most likely will move away. Because they will say, you have already accepted one letter of indemnity.
Hello. So the general rule, absolutely correct. So letters of indemnity are very, and I'm doing two major cases right now. Letters of indemnity are what trade takes place. So the English high courts have dealt with it very well. Yes, the P&I clubs will not always back off because it's not an illegal document. So the general law is that you cannot deliver without an original bill. If you do it at your own detriment, which is a little different to an LOI which you get for, let's say, backdated bill of lading. Or let's say if I've loaded, as he says, I've actually loaded my mate's receipt, because there are two things. A bill of lading is done as per the mate's receipt. The mate's receipt is what? Mate is the master. So mate signs the mate's receipt and he says, this is what is loaded on my ship. And the bill of lading is normally issued by the charterer and signed by the agent on behalf of the master. And that is done on the basis of the mate's receipt. And charter parties will also say in there that you must issue bill of lading as per mate's receipt. But let's say you issue a bill of lading and the owner knowingly issues, I've loaded 50,000 tons, but he says 55,000 tons. And you get an LOI for the 5,000 tons. And it happens. Those bills of lading, those LOIs are fraught with fraud, because I am defrauding a buyer. right? So those LOIs in court of law have no meaning, because you have actually perpetrated fraud by accepting an LOI which says I've loaded 55,000 tons instead of 50, because you've induced the receiver to pay value of 5,000 tons when you knowingly have not carried it, or you have backdated, because a lot of times you'll have in international trade, for example, duties, right? Now from tomorrow duty will rise. So you say backdate the bill to today, knowing fully well that the ship did not load or the ship was not there. So you're defrauding. Now those LOIs have no value. But an LOI which you give for receive for cargo without bill of lading is not an illegal bill of lading. It's a bill of lading. It's a LOI you take on the behest that you know that the actual bill of lading holder may arrest the ship, and you will have to pay compensation. In such cases, as correctly said by Hari, the P&I club will not pay for the cargo, but they will support you on litigation. So I've had two cases, and both are very interesting. One was in the United Kingdom and one over here. And now this jurisprudence is really getting very, very interesting because of the bankers. And now the English court, the Singapore courts have all held different judgments. We had a client who had a ship owner who loaded cargo in Indonesia of coal. It discharged the cargo in Gujarat, in Navlakhi, and went off on the basis of an LOI. And the other thing you have to worry about is when you take the LOI, it's a document of a company. If the company is not worth the paper, the LOI is also not worth the paper. So he took a LOI from a company called Visa. Now the cargo was discharged, and then suddenly we got a notice from the Indonesian shipper saying that we are holding the original bills of lading. Please do not discharge the cargo. Please discharge the cargo only as we tell you. But of course, we discharge the cargo. Now, when you take an LOI also, there are two things you can do in an LOI. You can take an LOI for discharge, and you can take an LOI for delivery. If I've taken an LOI saying I'm only discharging because I don't want my ship to be a warehouse, you're protected because you're not delivering. You can then deliver to whoever comes with the original bills. But if you have a LOI which is for delivery also, of course you've delivered, then how do you give the original bill of lading holder the cargo? So the original bill of lading holder went and arrested my vessel in Singapore, and I had to put up $4 million cash in the court because the club said, I'm not going to put, you have given it, your choice. We filed a writ in the Gujarat High Court to stop delivery, and the Gujarat High Court said, no, he has paid because the final receiver was Binani Cements. They said he has paid, he's shown money that LC, so I am delivering. Now in this whole process, we managed to get the LOI that Binani Cement had given the ship owner. There was a back-to-back LOI. Binani Cement had given to the ship owner and Visa had given to us. Visa had gone bankrupt. So the ship owner's LOI, we could not do anything. Basis this LOI from Binani, although I have no privity with Binani, in England there is an act called the Third Parties Contract Act, whereby I can sue a third party if he's linked. I went and started a case against Binani Cements. And it's a very well-known, it's a reported judgment, it's Great Eastern Shipping versus Binani Cements, in which the London High Court said that an LOI is a sacrosanct document in shipping, so long as it's not tainted with fraud. And it must be given business efficacy. And therefore, Binani Cement was ordered to pay us $4 million plus the cost, which I had to pay the Singaporean, right? And then they took it on appeal, and the appeal court held in our favor. Both judgments go in favor of an LOI. Very good, I recovered my money because Binani Cement at that time, now Binani Cement has gone into liquidation. In those days, Binani Cement had a lot of money, and I got my $5 million with cost. Now I'm doing a present case in the Chennai High Court right now, where my ship owner has delivered the cargo. It was oil coming, it's a big fraud which was played. Oil was coming for Aramco. It was rerouted by the charterer to be delivered to a big oil company in Singapore. And that delivery took place against an LOI. Now, when we looked at it, and then of course our vessel got arrested by the bank, who said, I am holding the bill of lading because I have not been paid. So we had to put up $8 million in the court, and we were looking for the LOI holder. The company had gone bust. So it's a risk that you as a ship owner have taken. That LOI may be worth full money, it may be worth zero money. Now in this case, the twist that took place is now in England and in Singapore, bills of lading laws with finance companies have changed. And what they are saying is that a finance company, a bank, when he knows that he is doing a credit facility and he's saying that you have a 90-day credit, he knows that the receiver will not take delivery with the original bill of lading. So he is not financing basis the bill of lading because he knows that the receiver will take the cargo without the bill of lading. And therefore the Singapore court and the English court, on the facts of those cases, and I must put that caveat as a lawyer, on the facts of those cases held that the bank was not entitled to the money because the bank did not hold those bills of lading as a title document and therefore was not allowed. So we are running the same case in Chennai. Unfortunately, we've lost the first round and we are in the appeal court. The order has been stayed, so we will know what will happen, but I'll tell you. But exactly the same thing is going on.
Great. Sir, back to you. So how far foreign jurisdiction clause in bill of lading binding on Indian courts?
Yeah. So there is a provision under the Contract Act, which you all know, which says that any agreement entered into between parties ousting the jurisdiction of a court is null and void. Okay. So when you look at a jurisdiction clause in a bill of lading, you might have a doubt whether that violates Section 28 of the Contract Act. But there are judgments of Supreme Court, I think it is Shanmuga Vilasam Cashew Company case, where the Supreme Court has held that for commercial purposes, a bill of lading containing a jurisdiction clause have to be given effect to. Therefore, if the bill of lading contains a clause which says that there is a claim, then it can be brought only, let's say, in Hamburg or in Copenhagen, then that is binding on the parties. Recently, there is a judgment rendered by Kerala High Court on the issue similar to this, where the Kerala High Court was considering a question as to whether goods which was stolen, once it has been discharged at the port, whether the jurisdiction clause would apply or not. The Kerala High Court took the view that the bills of lading applies only from tackle to tackle, which means once the goods are being delivered or discharged at the port, then the bills of lading will have no application. And based on that, the court held that the jurisdiction clause is not binding on the parties.
So over to Raja sir. So the Admiralty Act of 2017 sets the timeline of 45 days plus an additional of 30 days for auctioning the ship. And in Singapore and UK, sales are much faster. But in India, is it practically possible for a sale of ship or an auction of ship in 45 days?
Yes, it is. I think India is extremely good at selling ships. We have sold many ships. It's a matter of what is the purpose and who's going to sell the ship. The statute provides a default position that if no one is coming, then the court can sell the ship. But otherwise, after 45 days, any party who wants to sell the ship, if no security is put in, can apply to sell the ship. Now, in 80% of the cases that happen in India or anywhere in the world, the owners will either come, and the reason the ship is not being sold is because the owner has entered appearance and is fighting the case to vacate the arrest. Now, if I am arguing that the vessel is wrongly arrested, then there cannot be a sale. So sale only really is linked to a situation where either in a situation that is abandoned, where the owner is not participating, then one of the parties ought to go and sell the ship. And if they file for sale of the ship, Normally, it will be sold within 30 days. 30 to 45 days, a ship is sold, if it is properly done. So we've done many such sales in Andhra Pradesh, Chennai, Gujarat, and they are as efficient.
I will add to Rajesh, sir. We arrested a ship about 2 months back in Gujarat, and within 45 days we put in an application, and the court has already given an order for inviting tenders for sale of the ship. It's very much possible. Yeah.
Sir, now I would like to ask Mohit sir. Sir, the MLC requires a seafarer cannot remain on board beyond 11 months. Right? When the abandonment is happening, almost the seafarer might be already crossed that particular period of 11 months. But when ship is arrested, a minimum skeletal crew is also still required for the safety of the ship. So these obligations often conflict, right? So how should this be addressed effectively?
Yeah, so I think you're talking about, so just like whatever you told, let us put it in a facts. There was a ship MV Erebus, it got abandoned in Djibouti, port in Djibouti. Now what happened, ship owner have just abandoned the ship along with the seafarer. So there were 20 seafarers who were stuck on that ship. 10 of them were allowed to repatriate, they went to their home. But remaining, so last, I think there were 5 crews who remained on that vessel, who were not allowed to leave that vessel. Why? Because port did not want to keep an unmanned ship in their port. Because you just imagine, it's a big ship. It's not a parking area. It's not a small car or a small bike. It's a ship. So generally, ports sometimes have been reluctant in keeping an unmanned ship. Now here comes, like as you asked here. So on one hand, there are like international law talks about minimum manning requirement, that every ship should have minimum number of crew. Always it should have a minimum number of crew. So there have been cases where port have not allowed the sign off from the vessel, or the ports have not allowed disembarkation of the abandoned crew because they were concerned with the safety. They thought that ship may sink, ship may catch fire, so they don't want to keep an unmanned ship in the port. Now again here, like when it comes to looking at it from the perspective of the port state, so when you see this issue from the perspective of Maritime Labour Convention in particular, Maritime Labour Convention specifically says this thing, if you see Regulation 2.5, that port state has duty to facilitate crew change, and port state also has this duty to assess the abandoned seafarer or any seafarer for that matter. Because and also furthermore, there are many human rights treaties as well. Because whenever a seafarer is stuck on that vessel, that can also generate a human rights crisis for him. It could be a floating prison for a seafarer. In one of the cases which happened in, I think, some Gulf country, there the seafarer have to swim every 15 days to bring rations from the port. So sometimes those issues where seafarers have been stuck on the vessel, confined on the vessel, it generates human rights crisis as well. So maybe the port state human rights obligation comes also into picture. For example, basic human rights treaty, if you see ICCPR, ICESCR, those have been ratified by almost all the countries, have wide acceptance. ICCPR in Article 6 talks about right to life. So not only we can look at this issue from the perspective of Maritime Labour Convention on maritime law, it's also an issue which generate a lot of humanitarian concerns as well. Now as far as balancing two things are concerned, on one hand, port state don't want to keep unmanned vessel. On other hand, port state also have to protect the human rights of those people and have to comply with what MLC requires. Now middle way or the solution of this could be that maybe that ship can be shifted to a place where it could be kept unmanned. It could be transported, it could be shifted to some of those places, or maybe port can keep, and in some of the cases port have kept some people on that ship on its own cost and allowed existing crew to disembark. So this could be possible solutions.
So we do quite a lot of these cases where crew are involved. On an Indian parlance, let me just clarify, MLC only applies to Indian ships. The Indian MLC law does not apply to foreign ships, number one. Number two, Indian crew members usually, and Mr. Mukherjee will be knowing it better, must go through what we call RPSL agents. And the RPSL agents are answerable to the Director General of Shipping, and they have to give a bank guarantee for repatriation of crew. So this is for Indian crew going outside. The important factor is that if the crew chooses to get onto a ship which does not have proper P&I cover, or thinks that he wants to get onto a ship which will give him a quick money, he does that at his own detriment. The crew has a choice to get onto a ship through a proper RPSL agency. The Indian government protects them. They will get onto a proper ship with proper P&I cover because the RPSL agent is audited to be checked that they have all the necessary problems. And if they go on a ship which is covered by a P&I club, who are the financial insurers, they will take care to ensure that you are repatriated. But if you get onto a ship which does not have a good P&I cover, or you get onto a ship which, let's say, is stranded, etc., there are various things that one can do. In India, we see this on a regular basis. Now it has stopped because the Indian government has brought in what is called the port entry rules, which only allow ships which have got proper P&I cover to come in. And if they, by virtue of that, if the ship is stranded or something happens, then the government will get hold of the P&I club to ensure that the crew on board are properly looked after, or take steps to sell the ship and repatriate the crew. Right? Now, we've had 2 or 3 incidents, one in Andhra Pradesh, where a ship was stranded, the company went bust, the P&I club disappeared, and what you do then is that the crew approach, ITF is there, and there's a very, very strong lobby of labor union. ITF will assist the crew to file a case to sell the ship and get the crew off the ship. And in fact, in the interim, if they have been there for very long, we even have cases where the court has ordered that the crew be repatriated and the Director General of Shipping get crew to sit on the ship during the period while it is being sold. And their claim is protected because under Indian law, Admiralty law, crew members' wages, crew members' repatriation is the first claim that is allowed from the sale of those ships. So that is one way of doing it. The second way of doing it is under the MLC of that country, we have had cases where ships have been stranded in Indian waters, where the P&I club has come forward, has arrested the vessel, sold the vessel within 45 days, and have repatriated the crew. So it is very much possible. The crew that we hear who are being stranded, there is one set of sad crew, which is the piracy crews, obviously over which not much can be done, and the Indian government has been very successful. In fact, I think 2 days ago they got some crew back. I was involved in one where they took 2 years, and we had arrested a vessel and got compensation for the family members for 2 years for the government of India. And the other group of people are people who leave the country and then go and get jobs on ships, knowing fully well that those ships are not worth getting on, either because their service records are not good and that's the only place they can get on, or they're probably being paid extra because they're doing a particular African or Indian journey or somewhere where it's risky business. So that is not been approved by the government because they are not going through the dedicated RPSL agents. So then it's very difficult to say that they have done it on themselves. So, each case turns on their own facts, as it were.
So over to Captain, sir. Sir, MLC has significantly changed crew welfare obligations. So from dual perspective as a master and now a lawyer, how challenging is it for the Indian ship managers to manage the commercial pressures with MLC compliance?
We're asking that question to Mr. Mukherjee. But yes, like Raja sir said that we have to go through RPSL, and all the speakers here have already covered that. Dr. Mohit also said that. Now, what happens is abandonment, first of all, abandonment. Let me clarify, MLC as well as when MLC was incorporated into our Merchant Shipping Act, MLC is very categorical that if you don't get paid your wages for 2 consecutive months, then it is automatic abandonment. Don't have to wait on the ship for 11 months or 10 months. Or we had a case where the ship was arrested and the people stayed there for 3.5 years in Sri Lanka. So don't have to wait. 2 months, the moment 2 months are over, you have not been paid, it is automatically abandonment. That's number one. So there is, on conspicuous places on the ship, there is a certificate, MLC certificate, which is stuck by the management and the ship owners, which actually gives the phone number and the email of the company which has given you insurance. A ship crew has to actually approach that person. It's a 24 hours helpline. Now that's number one. Number two, all the insurance certificates on the ship expire on 20th of February. Most of them except hull and machinery. Now what if suppose you're not paid in the month of January and February? Your claim will actually arise on 1st of March. But the insurance is already expired on 20th of February. Then what is the option available to you? Then comes what Raja sir had said. We'll talk about from the Indian context. Our Indian Admiralty Act 2017 Section 4 says that master and crew's wages are a valid reason for arresting a ship. And not only that, it goes on to Section 9, which is maritime lien. And that gives 5 maritime claims which are considered as maritime lien, which is the strongest lien available in any industry. This is called the maritime lien. And the number one lien in that list of priorities is the master and crew's wages. So number one, you approach the insurance. Number two, if your insurance is expired, you have the full right to arrest the ship. And not only arrest, you can even impose a maritime lien on the ship and have the ship sold in 45 days. I'm speaking purely on basis of Indian law.
Yes, sir, please.
Yeah, there is one interesting incident that happened. I mean, it's a kind of an anomaly to the MLC system that we see or know of. On one vessel recently, USA imposed sanctions. So they sanctioned the vessel, also sanctioned the registered owner of the vessel. Now the registered owner of the vessel is sanctioned and the vessel itself is sanctioned. Now the moment that happened, immediately, first thing that happened, P&I Club, because they deal with USD and US financial system, they left that contract. They said that we are not going to support anything, so we are leaving out, because they will not be supporting anything sanctioned is something which is not supported by the law. So they said that it is unlawful to support the sanctioned vessel, so we are moving out. Now, P&I Club is gone. Now, since the vessel is sanctioned, the flag of the vessel, now the country where the vessel is registered, the flag of the vessel, they, two things happened actually. The owners is there, there's an incorporation done saying, for example, Panama. The vessel is registered in Panama under Panama flag. The company also, the registered owner, is also a Panamanian company. Now, since the vessel has been sanctioned, so what the Panama government did, the register of corporations there, as they call, they dissolved the company, they revoked the incorporation certificate of the registered owner. Now what happened? There is no owner for that vessel. Secondly, since there is no owner of the vessel, the Panama flag, the administration, that is what we call DG shipping here, is the Panama administration over there. They said that we cannot register the vessel, keep the vessel registered anymore. So they also revoked the flag of registry. Okay, so they are no more the flag of that vessel. Now the flag does not have owner, does not have the registered owner gone, flag is gone, P&I Club is gone, and since, say it's a bareboat charter, now since the sanction was on the bareboat charter is gone. Now the vessel owner, who is the actual beneficial owner, he does not have the, you can say that, that control, even though he is the Shareholding is there, but then the legal control does not exist on the vessel. So there is, we cannot, I mean, we were the managers, so that's why I'm telling the story. Okay, so now we being the manager, we have no locus standi now, because there is no bareboat charter is gone, because they were sanctioned. The moment they are sanctioned, they are no more the beneficial owner or the manager, as they call, they say that we are cancelling the bareboat charter. So bareboat charterer cancelled, owner is gone, flag is gone, everybody is gone. Now the crew is on board. Now now it was just before the end of the month, salary time coming in. So we had to pay the salary. So now the position came, how to pay the salary, who will pay the salary? And the salary has to pay in, normally it is US dollar. So who will pay the US dollar? Because the body who pays this US dollar to the sanctioned entity will also fall into the ambit of the sanction. So we cannot pay. And the crew started making noise. The matter was then taken to the union, local union, to the officers union, crew union, DG shipping as well, ITF as well, and everybody vanished. No one to be seen. We are the ship manager because we are supposed to be ship manager, but without any contract now valid, how do we even go and help the crew? We were in a great soup situation. The crew was shouting because they don't have their fuel decreasing and everything depleting. Then we asked the beneficial owner that give us some funds so that we can route. They said that, how can we give you the fund? We cannot give you the fund, otherwise we will be getting in. So then how then we can give the fund? We cannot also give the fund. We approached the US Sanctions Authority, which is OFAC, Office of Financial Assets Control. Okay. So we approached them saying that the vessel is now abandoned. Just outside the port limits of, one was in Vizag, one was in Brazil. Brazil was partly loaded, so it was a kind of a dicey situation. Crew did not want to stay on board, but no one can pay them to take them out. No agencies are ready. So then we had to approach them, we had to convince them that unless you give the relief for some time, a window period, that we can take the crew out, do something with the vessel, because vessel, we cannot leave, just abandon. The crew can also abandon the vessel, but then how can they abandon? Okay, because some boat has to go. Port authority will not allow simply to go outside the port limits and take them. Maybe they would, but then that's an extreme situation. We cannot just leave the vessel in the middle of the ocean and then come out. Something had to be done. So after a lot of convincing, they gave the license to, and then the worst part of all, the communication provider, that is SATCOM, VSAT, they said that we cannot support anymore because one of their shareholding partner is a US entity. So they had to pull out. Now there is no communication, nothing available to go with the vessel because nobody wants to get into the sanctioned entity. So finally, after a lot of convincing, we got the window with the window license now to operate. We have got everybody, P&I come in and all that, everybody came in to support the crew. So that is where it's a kind of an anomalous situation where even though everything is there, but the entire machinery breaks down in situations like this.
So my next question is to Ari sir. So what is the evidentiary value of an unstamped charter party contract in an arbitral proceeding in India?
Under this Indian Stamp Act, a contract for getting a vessel on hire or a charter party needs to be stamped. Now there is another provision under the Stamp Act which imposes a bar on the judicial forum not to look at an unstamped document, or in other words, it cannot be taken in evidence if the document is not properly stamped. The earlier view of the courts was that it is a curable defect in the sense that you can pay the deficit stamp duty and make the document valid. But in NN Global Mercantile case, a 5-judge bench of the Supreme Court held that an unstamped document is null and void. Therefore, for example, if it's a charter party contract, which contains an arbitration clause in it, then the whole document will be treated as invalid and cannot be looked into by a judicial forum. So this has created a lot of commercial issues, especially in shipping, because if you don't look at the contract, the underlying contract, which contains an arbitration clause, you cannot even go in for an arbitration. Now this was reversed in a curative petition by the Supreme Court consisting of Justice Chandrachud as the Chief Justice. A 7-bench judge of the Supreme Court held that it is still a curable defect and also drew a distinction between an invalid document and not something which cannot be looked into as evidence. So it held that just because a document is not stamped properly or insufficiently stamped, that will not make the document void, but only can be cured by paying the deficit stamp duty. So for the time being, we are in safe condition that any unstamped document which goes before a judicial forum can be treated as valid if sufficient stamp duty is paid on that document.
So moving on to Raja sir. So Indian Admiralty courts generally apply lex fori rule. So while determining maritime liens. So Section 9 of Admiralty Act restricts for only 5 maritime liens, and bunker supply claims are excluded. So where many countries have accepted bunker supply claims as a maritime lien. So like, what do you think? This is a narrow approach and there should be a reconsidered and the act has to be amended?
So I'm an owner's lawyer. Being an owner's lawyer, I don't think it needs to be, because it has been brought in through the Maritime Liens and Mortgages Convention. So Section 9 and 10 are actually verbatim of the Maritime Liens and Mortgages 1993 Convention, which we brought in. In fact, there's a tweak because, of course, we give crew first priority. Internationally, salvos have first priority. Only in India, crew have first priority. And the Supreme Court has also held, even before our Admiralty Act came in, this matter was taken up to Supreme Court, and Justice Nariman, in judgment of MJR Steel, held that India follows English jurisprudence, and therefore bunker supply, necessary. Bunkers not, you can't just hold bunkers, it falls under the caption of necessaries. Necessary supply to a ship is not a maritime lien. It's only in certain countries that it is considered a maritime lien. In fact, it is mainly in the, not in the Commonwealth world that it is considered a maritime lien. It is in the codified civil world that it is considered a maritime lien, such as in France and all, and the United States, where everything is a lien. You know, anything and everything is a lien under the US. So in fact, it was a very interesting court case which we had, because when we went to Supreme Court, Justice Nariman had done his education in America. So when we started arguing, he said, of course it's a maritime lien. And then we had to go through and run through the whole jurisprudence of Indian maritime law. And then he's written a beautiful judgment where he says under American law it is, but under Indian law, which follow UK, it isn't. So this is pre the Admiralty Act coming in, just about a month before the Admiralty Act came in. He refers to it, but he says that it hasn't come in, it's a bill. And then the Act has also come in, and the Act follows what is a maritime lien, going back by not only the convention, but also our jurisprudence. There's a judgment called Wong Fu, M.V. Wong Fu of the Apex Court, where Justice Umesh Banerjee also sets out what are maritime liens, and they are what is in the convention, and other than crew, salvage, torts, port dues, statutory dues, nothing else is a lien. You know, when we talk about lien, you must also understand liens in India have a lifespan. It is, so every lien is a maritime claim. In India, you have 3 years for all maritime claims, you can go to court. Liens have a lifespan. Once the lifespan is over, it becomes a normal claim. So for example, with crew claims, if I have a crew wage, the crew will have a maritime lien for 2 years. Although their right to file a suit is 3 years, their right to claim it's a maritime lien is 2 years from the date that it happened. If they go to court late on the 3rd year, their claim becomes a normal maritime lien claim and is pari passu everyone else. Similarly, salvage, tort, and statutory dues, it's a 1-year maritime lien. On the expiry of 1 year, if you haven't initiated an action and arrested a vessel, you become a normal maritime claim and pari pass to everyone else. You can't then say I have a maritime lien.
So, sir, to follow up on that particular question, so you were saying about necessaries, right? So when it comes to after a ship arrest, so the sheriff expenses is considered inside the sheriff expense, necessaries also comes into picture. So the entire priority changes now. So
sheriff expenses is a complete different phenomenon. Sheriff's expenses comes from so a ship is arrested. When a ship is arrested, what happens? The ship comes under the control of the court. The court now is the person looking after the ship. No one else is looking after the ship. Different countries have different rules. For example, in Singapore, if I arrest, I as the arresting party must put $20,000 with the sheriff, because sheriff will look after. Indian law says that the plaintiff doesn't need to pay anything. Now the ship is now in the hands of the court. Now the court has to maintain the ship. The court will sell the ship. Let's say if the ship has been arrested for, I've done a case for managers, ship managers, where I arrested 7 ships for fleet. And the crew wages were outstanding. The insurance was not paid by the ship owner. Now the managers went to court and said, this is under your custody. I, fleet, will finance the court to look after the crew and to repatriate them and to pay their wages and to pay the P&I insurance for that 1 month. And I, the fleet, will pay for the sale of the vessel, which is again something that the court has to do. And therefore, because it is the court who's doing it as custodial legis of the vessel, any expense that the court makes, he recovers first. Because the expense is not by me and you. We are just funding. The court doesn't want to use his own pocket. Court should, but he doesn't. So we say, we will pay you. Court funds pays for the whole thing. As soon as it is sold, if I had not funded it, the court had funded it, the court would have taken the money first. So here, the sheriff's expense is the first expense taken by the court because it's his money. Then the rest is kept for everyone else. That is why sheriff's expense is ahead of everyone else. But to be falling under sheriff's expense, you must go through the sheriff. You can't suo moto spend money and say, I've spent it. And that's the judgment of Swedish club versus which is where they said that the club cannot, you cannot just go spend money and say, I've spent it on your behalf. No. You have to fund it through the sheriff or get an order through the court for funding it. Then you'll get that money first.
Great. Debashish, from the ship's manager's perspective, how significant are legal risks like ship arrest or cargo claims in day-to-day operations? Do this risk shape how vessels are managed?
Yeah, normally, see, we manage about, say, 700 ships plus across. It's not very common to see ship arrest happening because of the cargo. Only few occasions that we come across. It's not so common. Why? Because whenever there is a dispute, that first some discrepancy will come, something will arise. Then it will come to a position where none of the parties will agree. Both the parties start disputing. Then the immediate attempt that becomes from the owner side and even the charterer side to get into some kind of a settlement agreement. That's the most preferred thing. But where, say, a dispute-related cargo quantity and something comes, I've seen one in last few years in India happening because of the cargo. The vessel was arrested in Haldia most likely. Okay, so it's not that often we come to see about the cargo-related arrests of the vessel because it's mostly taken the settlement route.
Do you think Supreme Court's Gayatri Balasamy judgment amounts to judicial overreach and goes against party autonomy in arbitration?
That's a very debatable question. of course, the majority view is that for pragmatic reasons, the Supreme Court can make changes or make amendments to the final award in exercise of the power under Section 34 of the Arbitration Act. So Section 34, as you all know, is to set aside an award. But under that, the Supreme Court said if there is some clerical or arithmetical error, then instead of relegating the parties back to the arbitrator and get an award which would take time and expenses, the Supreme Court can, exercising the power under 34, correct it. The minority view expressed by, I think, Justice, who was that? Vishwanathan, has taken the view that that goes against party autonomy. But the majority view is that it can be done under the Arbitration Act. I don't know how the international community would look at it, but I still feel that that is something which should have been left to the discretion of the arbitrators.
Abroad in England, the judges have the power to amend. In fact, in a lot of shipping matters, the reason that there are English judgments is because by the time they go to the court, and if the court doesn't agree, they in fact pass the judgment rewriting the award.
But it entirely,
I think with the Indian parlance, Indian jurisprudence as it is today, I think I would probably agree with the majority, because as it is, to have reached the Supreme Court would have taken 10 years. For Supreme Court to set aside and said go back to arbitration, and for it to come up again, it would take 20 years. And therefore the whole point of arbitration would have been lost. And if it's a clerical mistake, I mean, the Supreme Court was very clear they will not go into the merits of the case. It was very technically clerical mistakes or corrections, which is already there in 34(4), where one could have sent it back to the tribunal. But the question is, having reached Supreme Court, to send it back will mean another 3-tier court case for 10 years, which is undesirable.
So, considering the time, I will go for a last question to Mogit sir. Sir, MLC prohibits crewing agency from charging seafarers from recruiting and placement agencies, but yet exploitation continues, right? So, with new amendment, with the new act of Merchant Shipping Act of 2025, with only 2 lakh penalty under this act, do you think this is generating a strong deterrent for the RPSL agencies?
See, there are so many reasons. So you have the problem is there because when GMU conducted a survey with ISWAN, where we interviewed, we surveyed many of those people who have been defrauded. We found that there are, we specifically looked at the background of those people. So we found that most of the people who are defrauded, they are newcomers. So maybe they want job, and in market there are not sufficient job available. So they may fall prey to those people, those fraudulent recruitment agents. Of course, it's a real problem. So I think there are so many factors which have to be put together to deal with this issue. And one of them, most important of them, is the awareness. So that is something because because the demand and supply gap is one thing which is contributing to all those issues as well. Now, let me talk about how law, as you pointed out, how law can deal with this issue. So earlier there was no penalty because if you see recruitment and placement rule 2016, specifically they didn't talk about anything as such. Now they have imposed at least something. There could be, it could have been made much better because there were many people who were talking about criminal penalty as well. But of course that is still there. You talk about general law, general criminal law. If suppose I have been defrauded because of some recruitment agent, I can of course use my right existing under existing criminal law. Maybe 420, or new penal code provisions could be used here. But of course, the Act, Merchant Shipping Act could have provided that imprisonment as well, but it has not.
That's it. Anything else? Okay. So, ladies and gentlemen, we have covered a wide range of issues today, from ship management, charter party disputes, admiralty law reforms, seafarers' right, and digitalization in shipping law. So with this, now the floor is open for the question. If audience have any questions, they can put forth.
So my question is to Raja sir. See, as we know, the bill of lading is a title document, so a negotiable document. So, in the case of digitalization or enforceability, how is going to be possible? Is it correct? Can you hear me? The bill of lading is a title document in the shipping transaction. So, in case of in terms of enforceability for digitalization or fraud prevention for the electronic e-bills, bill of lading, how that law is going to be addressed?
Hello. Yeah. So as of now, there is no law. As I said, the Bill of Lading Act has not been amended to include e-bills.
Okay.
So one has to be careful. But there is no law, and that's exactly what, as I said, I was reading from the Hindu, where the minister has said that for e-bills, they want to bring in a new law, like in Singapore. In Singapore, there's the electronic documentation law. So they are planning in India also to bring a similar law to that.
But in the absence of law, that who's responsible for the due diligence?
The parties are responsible for due diligence. No one else will be.
The parties only.
No one else will be. But also, as of now, e-bills are still not that common in India. You mainly have the physical bills, or what we have for container lines is bills which are collected at source. So the carrier collects it in whichever country and then issues a DO for the delivery in the port of discharge. So there is disputes which arise, but it's more due diligence on the part of the parties and who they are contracting with. And most of the disputes you will find is with when you have NVOCCs. It's never a real dispute with the mainline operators. In container trade, it's a big dispute with the NVOCCs because there's a huge amount of money transaction goes between them and you don't know where the bills are.
One more question, sir. You have mentioned that Indian MLC does not apply for the seafarer when they are in the foreign jurisdiction. So who will be responsible for rescue of
the flag state? You have to check the flag.
Flag state.
Flag state of that. The Indian MLC applies for Indian flag vessels.
That's all.
Similarly, the flag state like Liberia or Panama, they will have MLC also included because they're all part of the IMO. Okay. Most of the countries would have brought it in.
Under the IMO.
But therefore, for an Indian crew who's trying to get on a foreign ship, it is important that you go through the RPSL agent because they have been a lot of obligations have been put into them to ensure that when they put a person on a ship, that ship complies with the relevant conventions. So that if something happens, the person that the government, so the family of the Indian crew will go to DG Shipping, the DG Shipping will go to the managers and say, you took on the RPSL, bring him back.
Okay. You also mentioned, sir, that when the ship is port entry, that's supposed to be, the ship owner is supposed to be with the P&I authority. So you have a P&I, then you will see where will be taken care of.
So you have the port entry rules allows all IG P&Is,
okay,
international group P&I, which is 90% of the world's fleet, and they also list non-IG insurance companies who are approved by the government of India. Their ships covered by those insurance are allowed into India.
But port of entry is mandatory for the Indian government?
Yes.
It's mandatory.
You have to have that P&I cover to come into Indian waters.
Okay.
For any port.
Any port.
Not for trade, not under UNCLOS when you're going, let's say, from Ceylon to Pakistan or Ceylon to Dubai. If you're crossing the EEZ, no. But if you're coming into any port, that's why it's port entry rules. If you're entering any port of India, you must have that.
Adding to what Raja said, see, if an Indian seafarer who is working in a foreign vessel is obviously recruited through the RPSL. So if they don't comply with the requirements under the MLC, then the DG Shipping can cancel or suspend the license of the RPSL. as of now, that is the only thing that can be done with regard to, violations.
And repatriate, because they have a bank
yes.
guarantee given for
Yes,
repatriation.
yes,
so then DG can actually suo moto get it back and encash the bank guarantee and
Yes.
take that in.
Yeah. So let me add to both their comments. First question is MLC. Okay. Now India is a party to that. So are main countries. Most of the countries are party to MLC if they are operating ships. Now what happens? In every flag state, they will first adopt that MLC convention, then they will run through it. Either they will accept in toto, or they will make some changes, amendments to that, making it more stringent. Cannot be lesser. So it can be stricter but not lesser. So once that part is done, and now say the managers and owners are to take Indian seafarer. Now say we are managers here in India. So since we are managers in India and we have RPSL in India also, what we will do is that Indian government, after they adopt it, as per the regulation, they have one document called DMLC, Document of MLC Compliance. It is part 1 and part 2. Part 1 is of the government, which every owner has to ensure. Like we are managers, but the owner may be some other company. But when we are going to ensure that MLC compliance is there, we will see whether that owner has accepted or complied with the requirements of DMLC 1, which is the requirement of that flag state, what they have adopted, making it either stricter or as it is. And then they will ask the owner, you implement this. Now then vessel, they will have to ensure. So that means owners and managers together, they will implement it, which becomes DMLC Part 2. So that makes all the compliances there. And then it is followed by the managers and the RPSL agent. Now let me again bring one anomalous situation. In one of the situations right now we are handling is there was a collision in beyond territorial waters of Vietnam. Now collision was with the vessel and the one fishing boat. Now because of that there were some casualties. Now immediately the flag came in, then their investigators, and then port state, the flag through port state, and then the port harbor master had their own, then P&I also gave their representative, everybody came, and then also came one more agency called Security Investigation Agency, which is from Vietnam. Now they started their investigation and all that. After that, finally port harbor master said that there is no issue, we don't find anything wrong. There was some, both sides, it's a contributory negligence from both sides. Because of that thing happened. So the harbor master said that we give a release to the vessel. Then the local maritime administration of Vietnam, they also found nothing wrong. Okay, it's a contributory negligence, and whatever issues were there, the owners took their initiative to make the settlements. There was one death, one injury, and like that, and the boat was damaged. So all that was taken care by the ship owner. Now that part is also settled. Now what happened when everything was done, the vessel was allowed, we were trying to get the vessel released because the vessel was detained by the Security Administration, Security Investigation Agency, that is the local investigation agency there, police. They said that they will have to do the criminal investigation. Now after everybody, they gave the release, the vessel could not be released because the police wants to do their investigation. Then we said that the incident happened outside the territorial limits, so flag should take the control, but then there is no flag. We don't find the flag stepping in. It's a Panama flag. I don't think it's a good flag in that manner, but then we don't found any support from flag. Okay, that moment, I mean, after some time, the vessel was supposed to go out of the management. They were supposed to sell the vessel. So that time, naturally, finally, the Security Investigation Agency said that, okay, we will allow the release of the vessel, but we will detain the 2 crew who were on duty. So one second officer was there, one AB was there, so they were detained. Now when they were detained in Vietnam, the investigator said that we are not finished with. We will continue the investigation for some time, release the vessel. The crew got panicked. Now the management also got over because the vessel was going to be sold out. So we are out of the management. Now we are no more managers. If we are no more managers, naturally the crew managers are also out, means no RPSL for those crew. So managers are not there. RPSL is actually no more into authority, no signing authority. As manager, we cannot work. And the vessel was given to some Chinese owner. Now Chinese people, they don't bother about what two people were stuck in Vietnam. We reached out to DG Shipping. Then we reached out to this MEA. We reached out to embassy. We reached out to the local consulate general in Ho Chi Minh City in Vietnam. You name it, we reached out, okay, to find the help. The problem there is that even P&I Club, now because the vessel was gone, P&I then said that no more P&I there, okay. Now the vessel crew has been taken into detention on the investigation of the matter for criminal matter, so P&I won't support until they are absolved of that problem. So now the P&I is also falling behind. They are saying that, sorry, we cannot come forward until the matter get resolved. Okay, so all that thing was happening. Then we finally succeeded in convincing the owner and P&I club that at least support the crew. We will finance the crew. We will finance their cost. So we financed their cost. They were supporting the, through legal channel, getting the local lawyers. Now the question is that where is MLC and how do we get the support? Actually, in practical ground, this is a practical scenario. So we don't get support when practical scenario as such occurs, when manager and RPSL is no more RPSL, now some other agency, Chinese agency, is responsible for that vessel. Okay, now RPSL, who had been RPSL, is not authorized to act on behalf of that crew. So these are some anomalous situation, and when we reach out to DG Shipping, there is absolutely silence. They want the reports to be submitted. We do that, give the reports. But of course, I would say MEA is trying, Ministry of External Affairs. And the problem in that is that they have included in their penal code any maritime collision happening. They have also recognized international conventions like UNCLOS, but they say that they have their jurisdiction also applicable.
That's because if it is within 12 nautical miles, then it is whatever the country's law is. The international conventions all apply only after 12 nautical miles.
This is 22 nautical miles.
But different it may be at a particular place. For example, our customs barrier is up to 20 nautical miles. So each country has their own. But the problem that you faced is because there was a criminal case brought. If there's a criminal case brought against a party, P&I clubs and neither conventions will come into play.
Nobody will come into picture.
But therefore, it is the criminality which caused it, not otherwise. Otherwise, even if the ship... Otherwise, all of these conventions have a spillover period. So even after P&I is over, or even if P&I cover is not there, the P&I is still liable for 3 months thereafter. There is a spillover period within which it has to be done. So they can't run away per se. And if the incident happens in those periods, they have to finish it. Even if the ship goes out of the P&I club, for that particular cover, he is liable till the end of the whole solution. But if there's a criminal angle, they'll support you. If you get him acquitted, you can ask for reimbursement of all your money.
Yeah.
Now but not otherwise.
That part we have been taking. Now since it is 22 nautical miles outside, so it's as per their law also, it's like they're following UNCLOS, there is law of sea, and in that beyond territorial water, there are 4 things that they can act upon. There is the fiscal matters, customs related, immigration related, and something other.
For example, in India, the CRPC, IPC extends all the way to 200 nautical miles.
Yeah. That one.
Yes.
But then criminal one again will...
All the way up to 200. In India, it extends all the way to 200 nautical miles. Huh?
It is awaited or...
Sorry?
It's only by a notification, right?
No,
It
no,
has
no,
not
no.
been amended in
by,
the Act.
No, by statute. By statute, it is... that was the old, correct. By notification, the statute provided the application and said by notification, the area can be given.
Correct.
Under the Territorial Waters Continental Shelf Act, the Government of India extended it to 200 nautical miles, and then by further notification, appointed one police station at each state to having as for the 12 nautical miles to 200. 0 to 12 is your state.
No, but as per the latest Merchant Shipping Act, with the definition they have given territorial waters, and they have added one word now, coastal waters. Now they haven't defined coastal waters, but it is implied that you refer to the Coastal Act, which says up to 200 nautical
That we'll have to
miles.
leave the judges to decide.
No, it's already there in 2025.
There's no definition of coastal.
True.
Therefore, we'll have to leave it to the judges.
True, but it is 200
You will
nautical
argue
miles.
it is, I will argue against.
But it is 200 nautical miles now, yeah. But there is a gazette also for 200 nautical miles, yeah.
Just to, so just to add on to that question, so when we say about RPSL and bank guarantee, so the bank guarantee, whether it is like up to maximum of 40 lakhs, right? Like,
That's only for repatriation.
oh, so,
Not for wages.
okay.
It's only for repatriation. It is a way that the government... It is only for repatriation. It is a manner in which the government ensures that if the RPSL has also gone bust, my crew sitting somewhere, I have to expend money, it won't cost me more than that to bring them back to India. It only is to bring them back. That's all. Not it.
So any other questions? Any other question?
I have the question with regards to the fraudulent recruitment of seafarers. What are the steps can the government take to protect the seafarers in...
So the government has taken steps like the RPSL. You are supposed to go through RPSL. Unfortunately, the government has taken more steps in that they should not be allowed to go abroad unless they have, if they're a crew. But the courts have constantly struck it down by saying that you cannot bring in such rules stopping person from going and getting their job. In fact, Chennai High Court is the biggest judgments that have come out that has set aside all the notifications of DG Shipping where they have tried to protect the seafarers. They've said you can't. I mean, you're free to go. Today, you're talking about seafarer. Tomorrow, X gets a job in Dubai. It's a fraudulent job in Dubai. What can happen? Not on a ship. They go to do a job and they go to Dubai. So many stories. You go to the Middle East, passports are taken away, and then you are. What can you do? So therefore, if you go through proper recognized employment agencies, same with normal job in shipping, it's RPSL, you have that much protection. In the sense, the RPSL agent has been given the job to properly audit and vet the people they are putting the people on.
So I have another question. In case of action in REM, if a ship is arrested by a person, the crew is in the place of question. Their security, human rights also violated that.
Sorry, can you repeat that again?
Sir, their human rights are also violated that because they have the eligibility to work in the ships for 11 months, and they have to leave the ship in 1 month for their health issues. So in the case, can a government take steps to make any recruit?
Not really, no. When a ship is arrested, it's arrested. Until it is sold, we have ships where crew sitting for 3 years. It depends on the owner. Or the crew need to come and ask for sale of the ship. They can also ask for sale of the ship. And from that money, they will get their first payout. So they can go home.
Any other questions?
Thank you audience for your questions and thank you panelists for your answers. To formally conclude this session, I now invite Dr. Faumina C., Associate Dean of Inclusive Initiatives at VMLS to deliver the vote of thanks.
On behalf of Vinayaka Missions Law School, I, Dr. Faumina, Associate Dean, have the privilege and honor of delivering the vote of thanks at the conclusion of this Maritime Law Summit 2025. At the outset, I extend my deepest gratitude to all the distinguished dignitaries on and off the stage whose presence and invaluable contributions have enriched today's proceedings. Your insights have laid a strong foundation for the journey of the newly inaugurated Center for Maritime Law. I offer my heartfelt thanks to our Chancellor, Dr. A.S. Ganesan, whose vision continues to inspire us, to our Vice President, Dr. Anuradha Ganesan, for a constant encouragement and guidance, and to our Chief Strategic Officer, Mr. Suresh Samuel, for his steadfast support in steering the institution towards excellence. I also place on record my gratitude to our Dean, Dr. Anand Padmanabhan, for his leadership, inspiration, and unwavering commitment in guiding this initiative to success. Above all, I extend my special acknowledgement to Dr. A. Francis Julian, the man behind the vision of the center, whose mentorship and guidance have made the dream of establishing the Center for Maritime Law a reality. I sincerely thank our director, administrator, and facility executive for their support in ensuring smooth operations and coordinating throughout the summit. I extend my appreciation to the media and outreach committee, especially Mr. Jero, for capturing and amplifying the essence of the summit. I am deeply gratified to our faculty members for their guidance and to our student volunteers whose energy and commitment form the backbone of this event. A word of special recognition is also due to our housekeeping staff who work tirelessly to maintain a welcoming and comfortable environment for all. Above all, I must acknowledge the man behind the vision of the summit, Professor Saravanan, Faculty Coordinator, Center for Maritime Law. His foresight, persistence, and leadership transformed this idea into reality, and today's successful inauguration of the center is a testament to his dedication. Finally, I extend my heartfelt gratitude to every participant, guest, and supporter who joined us in making the summit a memorable and resounding success. Thank you.
Thank you, ma'am, for your warm words of gratitude. Thank you all for joining this insightful panel discussion and for participating in the Maritime Summit 2025. Your engagement has truly enriched the day, and we wish you a pleasant evening. I now request everyone to kindly rise for national anthem.
पंजाब सिंधु गुजरात मराठा द्राविड़ उत्कल गंगा विंध्य हिमाचल यमुना गंगा उच्छल जलधि तरंगा तब शुभ नामे जागे तब शुभ आशीष मांगे गाहे तब जय गाथा जन गण मंगलदायक जय हे भारत भाग्य विधाता जय हे जय हे जय हे जय 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 जय